My lord, I know it's not a time to mention, but item number 1575 of your lordship's monthly list is appearing wrongly under the heading transfer. It pertains to, my lord, an higher secondary matter where a person has been, my lord, deprived of selecting his optional subject. So, my lord, I also
Nothing
missed.
to do with transfer.
No, my lord. It is pertains to a person's selection of fourth subject. My lord, higher secondary exam will be commencing next month. My lord, I didn't get the opportunity.
Higher secondary exam next month?
My lord, the semester. The semester will commence from September. This match
12.
class 12.
Not higher secondary.
My lord, sorry, my lord.
Class 12
In our
examination.
time, it was only one.
Hmm.
Item number 1575 at 220, my lord. Page number.
1575. ওটা others এ দিয়ে দেবেন তো? Yes, please.
Grateful, my lord.
My lord, may I be permitted to mention one content matter
For what?
for inclusion?
No, today is not the
My-
day.
In the last order, it was my lord was pleased to mention for liberty to mention. That's why I.
But today is not the liberty granted time. There is a time for mentioning. Please mention.
My lord, few matters, my lord, your lordship disposed of.
Yes.
That matter, my lord, your lordship only directly
All right.
to.
Give.
My lord, this matter I am not giving because that matter Mr. Bhattacharya was appearing and information was got. That matter, my lord, it's not possible to correct. My lord, other matter relied on Vithi, which my lord.
To be mentioned, Devanta. But your other side should be there.
I shall inform.
Your lordship, one matter of monthly list item number 1781 for upgradation, your lordship. The matter is the petitioner has acquired higher qualification during his service tenure, but for the last 4 years, no pay scale has been increased. Today is not the day. I am not accepting it. Yes, call the list, please.
And I appear for the respondent. On the last occasion, my lord had directed us to take instruction with regard to approval of non-teaching staff in government institutions. My lord, I had indicated that the instruction that we have received is that there is no current government order governing approval of such non-teaching staff. My lord, we've also sought clarification on that as my lord had directed. So, my lord, the as it stands as on today, my lord, the respondent number 3 has written to the respondent number 2 asking for clarification in view of these cases that are being filed.
Who are you representing?
Well, the respondent number 2, 3.
It's a state.
Yes, the state. Yes, yes. So, my lord, this is where we stand.
DI sought clarification from the commissioner, and
Till date,
it has not come.
yes, my lord. So that is where we stand.
Let me just understand.
Additional the last order.
Approval of non-teaching staff of a DA getting school.
Well, it's being considered on an individual case-to-case basis, my lord. So that is where we stand.
Can you see the report of the second page? Second page. They said, my lord, the government order was cancelled subsequently by another government order. Both the government order has been set aside by this honorable court in the case of Vijit Sharma. I have
right. If the government orders are set aside, then what remains right now?
Remains, my lord, the previous government order. That is the, my lord, the 13 December 2011. No, that is, my lord, the.
What remains is this one. 3rd November 2000.
Page 18, 3rd November 2011.
G issued by the director regarding recruitment non-teaching staff of all DA subsequent
Certified as a stop orders.
And TI says, my lord, the no, at present.
Have you annexed that 3rd November?
Yes, page 18, 1-8. And on the basis of which, my lord, the coordinate bench in Vijit Sharma's case, my lord, the directed to approve the appointment. And also DI has referred, my lord, the Partho Saha. That has also been this honorable court delivered a judgment on the same point. This is the judgment of this honorable court. And page 26, DI said, we have no provision regarding approval. Simply online, my lord, the rejected.
Pages 34 onwards, the order that you have annexed.
Yes. That is the, my lord, the question was, my lord, the cancellation of government order dated 3rd November. That has been, my lord, the
Annexure P7 has been set aside. What was
P7, my lord, the cancellation. P7, you also will find
by memo DI to stop the operation regarding the recruitment of non-teaching staff. Yes.
P7, you also will find page 35, last 3rd paragraph.
Yes, I've seen. Two improved communications, P7.
That is one, my lord, to stop,
Ninth.
subsequent to cancel. Cancellation and stopping
And-
order, both the order has been set aside. So, my lord, the
So 3rd November
November
remains.
survive.
3rd
On
November.
the basis of 3rd November, my lord, the others, my lord, the have got approval. DI has granted approval. Also, I have, my lord, the just handed over Partho Saha, my lord, DI has relied upon. This is the rejection I have annexed, my lord, the judgment delivered, my lord, I have annexed. DI report, DI said, my lord, on the threat of contempt granted approval. But the no appeal has been preferred.
Please come. Learned advocate representing the state respondents. Was directed to revert with instruction with regard to the government order which relates to approval of non-teaching staff of a DA getting stop paragraph. Submission of the learned advocate is that no instruction has been forwarded by the authority till date. Stop. It has been
This
submitted
includes the
that
report that we filed and the
the
letter.
DI has already sought for clarification from the commissioner. Stop. Necessary order may be passed upon the commissioner to consider the prayer. Stop. Paragraph. On a perusal of the documents annexed to the writ petition and particularly the order dated 31st March 2014 passed by the court in WP 9640 within bracket W of 2012, Abhijit Sharma versus State of West Bengal and others. It appears that the court was pleased to set aside the memo dated 9th December 2011 passed by the Director of School Education and the
13th December.
memo dated 13th December 2011 cancelling the memo dated 3rd November 2011 which allows the DA getting schools to fill up the vacancies within the sanctioned strength from the qualified non-teaching staff. Stop paragraph. On account of setting aside of the memos dated 9th December 2011 and 13th December 2011, comma, the memo which currently survives is the memo dated 3rd November 2011. Stop paragraph. As now, paragraph.
The memo dated 3rd November 2011 specifies the norms which are required to be obeyed by the school authority in order to fill up the vacancy of DA getting schools in respect of the non-teaching staff. Paragraph relying on the aforesaid memo, the petitioner was appointed as a class 4 staff of the school in December 2023 with effect from 1st September 2022. Paragraph. The service of the petitioner is required to be approved by the District Inspector of Schools, Secondary Education, Kolkata. Was it forwarded?
Yes.
Yes. Page 23. 23
3 and 20.
along with the particulars.
Achha. The school has already forwarded the necessary papers for approval of the petitioner to the DI, SE Kolkata, in June 2025. The same is pending consideration till date.
No, that has been rejected, page 26.
Oh, consideration of sentence to cartoon. The same has been rejected in January 2026 with the observation that the DI does not have any provision regarding approval. The rejection of the District Inspector of Schools is absolutely contrary to the memo dated 3rd November 2011, which is currently holding the field. Paragraph. In view of the above, the instant writ petition stands disposed of by directing the DI, SE Kolkata, to take steps for approval of the service of the petitioner as non-teaching staff in terms of the memo dated, memo number 2116-caps GA/caps OM-8/95 dated 3rd November 2011. At the earliest, but positively within a period of 12 weeks from the date of communication of this order. If required, the District Inspector of Schools may provide an opportunity of hearing to the representative of the school and the petitioner at the time of passing a final order in the matter. A reasoned order shall be passed and communicated to the necessary parties. Communicated to all necessary parties. The impugned order of the District Inspector of Schools dated 28th of January 2026 stands set aside. Disposed. Eta ফেরত যাবে. You take back Partho Shaha.
My lord, I'm from the correction on the 4th line of the order, March 25, 2025. The EPPO was issued.
Only this.
Only this.
23 should be 25. Nari order. Please, yes.
Petitioner, my lord, para number 7,
Purbo Medinipur was mistakenly written instead of Jhargram, my lord.
It should be Jhargram.
Yes, my lord. Respondent number 3 was Jhargram DI, my lord.
All right, all right. Paragraph 7, second line. Instead of Purbo Medinipur, it should be Jhargram.
Chip, this is my application. Chip, it related to two issues. One is issuance of transfer certificate, and the second is whether money can be claimed for issuance of transfer certificate.
Money.
Lordship, what had happened is the application for transfer certificate was made beyond the date which
Who has claimed money?
the school.
Therefore, the respondent number 6,
My
7,
lord, I am holding Mr. Bed's brief, my lord, for respondent number 6 to 8, which is the school.
No, that's for a different school. We have no grievance because they have given us admission in that school. But this is the
Admission means you are a student.
I
You are
was
not an employee, not a teacher.
I'm a student.
You are a student, you want transfer.
I wanted transfer.
Oh,
The transfer certificate was being withheld on the ground
by
that
which school?
private school.
By which school?
Yes, my lord. Lordship will kindly see the last order which was passed on 18th of May 2026.
It is here.
I'm sorry. Yes, my lord. Kindly will take paragraphs 4, 5, and 6.
Guardian of the 13-year-old studying in Bharat Academy and Sciences. Order number 8. It on strict timelines, so there is not.
Not correct. Hello. Oh, Bharat. Lordship, pursuant to such order, the amount of 35,000 has been kept with the advocate and record of the petitioner, and the transfer certificate has also been given, and the child has taken admission in Julian Day School. Today, the only issue that is remaining before your lordship is whether they are entitled to charge the amount and whether it should be charged before this forum or there is another authority before which they should claim that such amount. Lordship, these are the only issues which are pending before your lordship. I will just place the.
No, today is not the day for hearing. Where are the affidavits?
Yes, my lord. Our affidavit in opposition, we have served them, my lord, within time perhaps. My learned friend is filing it at court, my lord. We have not received any affidavit and reply till date.
All right.
Reply file correct.
Why has it appeared as urgent motion?
My lord, we are also a bit surprised.
Well, it's subject to correction. Notice was given and perhaps, my lord, it was given to your lordship that transfer certificates were not given. Transfer certificate was not given. That, my lord,
But
conveyed
then,
a message of urgency.
Right.
That has been given. He's got
That's been
admission,
given,
everything.
the-
It's final hearing involving an amount of 30,000. That's all. A poultry sum.
Affidavit in opposition filed on behalf of the respondent number 6, 7, and 8 in court today be taken on record. Stop. It will be open for the filed in court today. Be taken on record. Is your reply ready? Is it ready?
Reply to? Lordship will kindly give us a week's time to give.
Acha. It will be open for the petitioner to file reply to the same within a fortnight. Stop. Liberty to mention the matter for hearing before any other bench having determination.
Great.
Deeply obliged.
Acha, be it recorded that the transfer certificate has already been issued in favor of the ward of the petitioner, and the student has already joined the transferee school and is attending classes.
Deeply obliged.
Lord, I am for the
Yes.
The petitioner before your lordship appeared for Lord the NEET 2026 Lord examination under the category of person with Lord benchmark disability. But in the initial Lord, when Lord the examination was held, Lord, I was given a compensatory 1 hour time Lord, which was required in law Lord to be given to a person with a Lord disabilities. Now, Lord, when the examination got cancelled, Lord, there was a re-examination, Lord, the NEET. Lord, in the re-examination, Lord, I was not given that, Lord, 1 hour compensatory time. Lord, that's my grievance before your lordship. Now, Lord, in the event,
The
Lord, there is
examination is long over.
over. Yes, that's the reason, Lord, I come before your lordship. Because, Lord, at the examination, the 1 hour compensatory time was not allowed to my client.
When was the examination taken? The
But that
second
was,
one?
Lord, in June.
June.
Lord.
We are in August. Why are you so late?
No, I gave them, Lord, because of the Supreme Court judgment which says that in the event, Lord, the compensative, Lord, time is not given, Lord, it has to be, Lord, based upon, Lord, the marks interpolation of marks. Now, Lord, as of now, Lord, they cannot have a re-examination according to the
Yes.
Supreme Court. Now, Lord, only remedy that my client has as of today is, Lord, that the marks is to be, Lord, made pro rata and given to him. He has obtained 155. Lord, his requirement is 194. If he is given the compensatory marks, Lord, on the basis of, Lord, that 1 hour time not allotted to him, Lord, he qualifies.
And how do the authority decide upon the pro rata marks that you are making?
Yes, Lord, that is based upon the Supreme Court decision.
Please show that.
Yes. Lord, in Avni Prakash, Lord, I have given, Lord, Lord, I can, Lord, produce the entire judgment, Lord, but for the paucity of my Lord's time, I have given, Lord, the only excerpts because these are, Lord, the bigger judgments. Now, Lord, your Lordship will kindly have a look into the 2-page, Lord, that I have taken from the SCC online itself. 2023, volume 2, 286. 2023, volume 2, SCC 286. Lord, in fact, Lord, the ratio is on the last page, Lord, of the compensatory marks. Gulshan Kumar's judgment.
Please read out what is there.
Lord, yes, Lord, your Lordship will kindly have a look at. Lord, paragraph, Lord, that has been, Lord, it might not tally with mine. Lord, the above statement indicates that the appellant has secured all India rank of such and such. Lord, I'm omitting that paragraph. Thereafter, Lord, in essence, the above submission boils down to the first respondent informing the court that in an examination of such large proportion, where 16 lakh students registered and over 15 lakh students appeared, it would not be possible to undo the injustice which has been done to a single candidate. The first respondent must remember that all the authority under the law is subject to responsibility and above all, to a sense of accountability. The first respondent is part F, governed by the rule of law and the constitutional requirement of observing fairness. Behind the abstract number of 15 lakh students lie human lives, which can be altered due to the inadvertent yet significant errors of the first respondent. 55. The first respondent as an examining body was bound to scrupulously enforce the guideline for written examination dated 29th August 2018, which provides for specific relaxations. The appellant has suffered injustice by a wrongful denial of these relaxations and lack of remedy by this court, which cause irretrievable injustice to the life of the student. The RWPD Act of 2016 prescribing beneficial provisions for persons with specified disabilities would have no meaning unless it is scrupulously enforced. In our view, the first respondent cannot be allowed to simply get away when confronted with the situation in hand, whereby injustice has been caused to a student by standing behind the situation of large competitive examination, individual injustices originating in a wrongful denial of rights and entitlement prescribed under the law cannot be sent into oblivion on the ground that these are necessary consequences of competitive examination. Conclusion, accordingly, in view of the above discussion, we conclude and direct as follows. The relief sought by the appellant for holding a re-examination for the NEET is denied. The appellant was wrongfully deprived of compensatory time of 1 hour while appearing for the NEET without any fault of her own, despite her entitlement as a PWD
and a PWBD. Accordingly, the first respondent is directed to consider what step could be taken to rectify the injustice within a period of 1 week. Further, it shall take necessary consequential measures under intimation to the DGHS. In the future, the first respondent shall ensure the provisions which are made at any NEET in terms of the rights of entitlement available under the RPWD Act of 2016 are clarified in the NEET bulletin by removing ambiguity as noticed in the present case. Having due regard to the decision of this court in Vikash Kumar Supra and the statutory provision contained in RPWD Act 2016, facilities which are provided by law to PWD shall not be constricted by reading in the higher threshold prescribed for PWD. By way of abundant caution, it is clarified that for the purpose of availing the reservation under Section 32 of the RPWD Act of 2016, or an upper age relaxation as contemplated in the provision, the concept of benchmark disability continues to apply. It was brought to our
What
notice.
reading is absolutely not here.
Lord, I am reading from Lord the printout of the judgment, and that is taken from Lord the SCC online.
Whatever.
That is.
None of
Lord, dear Lordship, may kindly have a look into Lord, this judgment.
I have followed your submission. Yes.
And Lord, there is another judgment which Lord I want to rely upon and assist your Lordship.
Perhaps this may not be necessary,
May
not
not be
applicable.
necessary,
I tell
yes.
your Lordship, kindly comes to, if your Lordship kindly comes to page 34. This candidate is suffering from mental disability, not from physical disability. My Lord, those who are suffering from, my Lord, physical disability, they are entitled to certain, assistance of scribe and lab assistant, whatever. That is not the case here. Now, interestingly, my Lord, I tell you, Lordship, this candidate attempted all questions. Yes, he has suppressed this OMR sheet. Kindly see how he has responded.
All right.
Yes, kindly see the first two columns. He has marked all 2, 2, 2, 2.
Oh.
And this is something, Lordship, he has not annexed. They have got the OMR sheet with them. They have not disclosed. And now, my Lord, he has got 155 marks, 67 marks questions correct questions, and 113 questions were.
First two columns entire.
Yes, this is. That has not been, it was
Check
available.
The OMR.
I'll
Suffering
respond.
from schizophrenic disorder or something.
That
He
is.
has not that he has. She has
That
not
is. It is.
the attempt to this thing. She has responded all questions. All this.
Not unable to attend.
Now, in view of this, your Lordship, kindly.
Is this a benchmark disorder?
Yes. This is certified.
Then kindly comes to my Lord, page 54.
Where is it certified?
Lord, I have annexed Lord the document, Lord the
Page
disability
34
certificate
is
at
the
page
disability
34. Page 34.
34.
Yes, he has 70% percentile disability in the nature of temporary and valid till such and such. The name of the affected body is brain schizoaffective disorder. In the first round, Lord, he was
He's
offered.
a case of mental illness. He's going for
Yes.
appearing in the NEET. I don't know how.
The first one they afforded that 1 hour. In the first round of examination, Lord, which got cancelled, they allowed. In the second one, they did not. So
There may have been mistakes. It is not that. But then the candidate answered all the questions.
the answer, yes. Now, Lord, the question here is that if the candidate is under pressure of Lord answering within the 3-hour period, Lord, the candidate is prone to Lord a mistake because
that is
he
not
was in
the
a
case
rush.
made out. That is not.
Wait. Look at the OMR.
I have seen the OMR. Lord,
The manner it's been done, it goes to show that he was not in proper state of mind to do it.
because of the fact that Lord, the 1 hour period which he had Lord in hand, according to the law, if he would have afforded that, he would have taken Lord a conscious Lord time for answering Lord properly. So this is Lord also an evidence of the fact that he was not put to rush and stress because of not affording the time.
Then one more aspect, page 54.
All that I'm before your Lordship is that if he is entitled to in law, he should be afforded that.
Now, what is the way out?
But that is what the Supreme Court says about the compensatory marks. All that, Lord, I say is, Lord, as of now, I don't ask for a re-examination.
Dangerous.
My Lord?
Extremely dangerous.
Lord, I can resist your
kindly
Lordship by
54,
referring to the
54,
Supreme Court judgment.
My Lord, the department has explained. He's not eligible, it's not eligible for. Kindly see page 54.
Yes.
That has been explained.
Who has explained it?
Yes, the Department of Empowerment
Section
of
officer.
Persons with Liabilities. She
What
made a
does it say?
complaint.
What does it say?
It says, and in your case, based on the record submitted by you, it appears that no such certificate was submitted. Therefore, you do not appear to have been eligible for the grant of compensatory time under the guidelines dated 29/8/2018. I mean, they have explained everything. And they have annexed.
Facility of a scribe, reader, and lab assistant shall be provided.
Yes.
And it is only for this purpose 1 hour extra is
Yes.
given. Where is the provision that a candidate who's suffering from mental issues?
Page 37, Lord, kindly come to Lord, their own Lord, the notification which says, and thereafter I'll take your Lordship Lord to page 40. At page 37, Lord, the instruction of the Ministry of Education, Lord, your Lordship will find at Lord, clause 13.
Yes.
The PWD or PWBD candidates must bring such and such. Kindly, Lord, omit that. Then, Lord, the second line, the facility of scribe. Also, Lord, your Lordship will omit that. The compensatory time, the third line it starts from, of 1 hour will be provided to the examination of 3 hours duration, whether such candidate having a physical limitation to write uses the facility of scribe or not. Scribe or not.
It is only restricted to more or less physical limitation.
No, thereafter, Milord, it also, Milord, covers, Milord, person with benchmark disabilities.
Yes.
That your Lordship will also find, Milord. Milord, at page 40, Milord, this starts from, Milord, the Government of India, Milord, page 38. Guidelines for conducting written examination of persons with benchmark disabilities. Page 38, the next page.
Yes.
Then in that, notification of 2018, which has been referred to by the Supreme Court, your Lordship will kindly come to Lord 12, page 40. So, Lord, I am covered under the benchmark disability. There is no doubt. I'll show the admit card under which they have issued.
Oh, admit card I've seen, it is mentioned.
Yes, Milord, and in the first instance, they afforded that. But 12, the word extra time or additional time that being currently used should be changed to compensatory time, and the same should not be less than 20 minutes per hour of examination per person, but allowed to use scribe, reader, lab assistant. All candidates with benchmark disability not availing the facility of scribe may be allowed additional time of minimum 1 hour. Lord, kindly mark this. All candidates with benchmark disability not availing the facility of scribe may be allowed additional time of minimum of 1 hour for examination of 3 hour duration. So this is without any qualification, which my learned friend says that even if I have attempted, I am entitled to Lord the 1 hour, not put to pressure of Lord completing the examination within 3 hours period.
Show me the list of benchmark disabilities.
Lord, Lord, your Lordship will kindly come to Lord the NEET guideline, page 45. Lord, this is Lord the information bulletin of NEET, which says that Lord para 2R, the person with benchmark disability means a person with not less than 40% of a specified disability where specified disability has not been defined in measurable terms, and includes the person with disability where specified disability has been defined in measurable terms as certified by the certifying authority. So here in this case, as I've shown, that it is 70%.
And that is the reason you say that it is a benchmark disability and you should be provided this benefit.
According to Lord, their guidelines. So, Lord, it is unqualified whether I take a scribe, whether, Lord, I attempt answering, Lord, each of the questions. And they admitted that I am entitled to that in the first round.
Will you be able to assist as to whether a candidate who's suffering from more than 70% disability, mental disability, would be a proper candidate to appear in the NEET examination?
But that has already been decided, my lord,
What
by
does
the
the
Supreme
court
Court.
say?
Lord, the Supreme Court says yes.
And if
I understand, my lord, what is playing in my lord's mind.
something's
But, my
happened,
lord,
if he turns out to be a doctor, it's all right. But then at the time of checking up a patient, examining a patient, if something goes wrong, then what is going to happen?
Lord, these questions fell, my lord, for consideration before the Supreme Court. Supreme Court cleared that and said that they are entitled to appear by way of a reservation.
No, reservation
Not,
is all
and
right.
not to the extent of, my lord, even, my lord, the candidates who are, my lord, blind. They are entitled to appear through braille.
That is something different.
For
The candidate is
examination.
mentally fit. The candidate becomes mentally fit. If the candidate is mental, it's only the mental unfitness.
CISO
Had it
affected.
been-
CISO is, my lord, it is basically, my lord, at times he gets affected.
Yes.
As your lordship knows, my lord, it is a
So when, suppose, assuming he is examining a patient and he has an attack of schizophrenia, then what happens?
there are possibilities of every kind of, my lord, the persons with mental disability, my lord. This is a possibility, my lord. I cannot,
Possibility,
yes, I cannot
yes.
rule out.
True, because that is the certificate. More than 70%.
But they are, my lord, also eligible, my lord, as a matter of policy.
The examination is neat. It is not a teaching job. It is not a clerical job. It is not instructor job or anything of that sort. You are treating
Medical.
patients. Anyway, what is your
Oh, my
submission?
lord,
I do not know.
Your lordship has seen page 34. The
Yes.
certificate simply says it is a case of mental illness.
Yes.
Now, if your lordship takes page 45,
Yes.
the at the bottom, office memorandum,
Yes.
Ministry of this, it was issued by the ministry circular for conducting the written examination for
Tell me
persons
one
with
thing. If you did not allow the candidate the 1 hour compensatory time for the second examination, why was it allowed in the first
I
one?
am not aware, I have no instruction with regard to that.
Because that is his case.
My
And
lord-
his admit card also says that he
My lord-
suffers from benchmark disabilities.
My lord, what has happened? What happens, your lordship? My lord, when a candidate applies for the my lord, the examination online, now he has to indicate to which category he belongs to. Then they are not checking the certificate or at that point of time. It is at the time of examination hall, they have to produce. Now they have annexed 2 certificates. Possibly it has not, it is blank. I don't know whether they have
No, it is there. Page 35, I can see.
Yes. Now,
Date of examination is 3rd of May. Where is this
That is the
next
first
admit
one.
card?
yes,
Next admit card?
The next admit card is, my lord,
that is immaterial, my respectful submission. Because
next
this, they have to mention the category.
at page 48. That is also there.
It is there. But tell me one thing, how do you allow this compensatory time? Suppose 3 hours is over, you take the papers.
No, they are allowed to
They are allowed to hold
roll.
for 1 more hour.
1 hour, 20 minutes per hour. That basis possible. That is
Yes.
the-
So
that means
minimum
3 hours,
1 hour.
1 hour,
is
3
like-
hours, 1 hour. That way.
Right.
Now they have to satisfy, before that they have to satisfy the center superintendent that the disability certificate, and also there is one annexer undertaking to be given. I don't know whether they have.
So what happens if the candidate just hands over the paper and says that within 3 hours my examination is over, and he walks out? How will the authority get to know? And how will the authority ask the student to stay back? These are all questions of fact.
Because, my lord,
Now we have
what
to
my lord
verify
said,
the.
I have an answer to this.
We have to verify certain facts from the center also, because the center is a
Yes,
maybe
center.
quasi what how much, whether they allowed the students to sit in the exam and continue.
When a candidate doesn't know the answers,
Yes.
even if a regular candidate, 3 hours, within 2 hours, it's over. Hand over the question paper and move
That
out.
is also a possibility.
It
Then,
happens. What possibility? It happens on regular basis. Right? So, what
then-
about this candidate? You never know.
then
Was
this,
he restrained,
kindly
not
see,
given, or
No,
anything?
it is my case in the writ petition that I asked for the extra time, and the invigilator said that no, I cannot allow you the extra time because it is not permitted by the center in charge or somebody.
So, instruction from the center in charge has to be
that is, and no, moreover, my
obtained.
lord, kindly see,
What?
is also
Nikki?
annexed. This is required to be
Submitted.
submitted.
At what point of time?
That at that point of that they are suffering from, my lord, the limitation.
What point of time is this required to be given?
No,
At the
this
time
is not
of
for the own
examination.
scribe, I believe. It is appended. That
Yes,
that
yes.
scribe
Yes,
appendix
it's a
to
scribe. He
appendix
doesn't
to
want.
scribe.
He doesn't want a scribe.
Yes, he doesn't want. Then the question is that whether as a mental,
No, if it is a benchmark disability, you
no, I'll
Okay.
have to then kindly keep it, my lord. I'll take further instruction, clear instruction, because on the face of it, my lord, I mean, lordship, I have satisfied lordship. She had attempted.
the
All
candidate
questions.
has attempted.
Yes, yes.
All
This is not
your lordship has
because we
seen
cannot-
two parallel lines here, blood.
Not held. Suppose I could have understood that he has not attempted some of the questions, last questions of the thing. So here it is a case.
Schizophrenia issue is playing in my mind.
It
I don't know.
is such a case that no.
Please come. Have you made
Can
the
I
center a
have-
party? Did you make the center a party?
Yes, blood. We have blood.
Center in
Kindly
charge, neat.
Center-
Kashipur Damdam.
center in charge.
Acha, the petitioner appeared in NEET UG 2026 examination and re-examination.
Center in charge. Yes, five. Five.
Stop. He has annexed a disability certificate in support of the submission that he is suffering from 70% disability under the category of mental illness. Page number 34. Check the illness. Schizo
Affective disorder.
affective.
It is written affective. It is affective. It is affective.
Schizoaffective disorder. Page 34. Stop the according to the petitioner, he ought to have been allowed 1 hour compensatory time to answer the questions. Stop. The compensatory time was allowed at the time of examination,
In May.
which was conducted in May 2026, but at the time of the re-examination conducted in June 2026, the same was denied despite request being made. Stop paragraph. The petitioner submits that he ought to be awarded marks on pro rata basis or some form of compensatory marks for denial of his right to be provided 1 hour compensatory time in the examination. Stop paragraph. Learned senior counsel representing the petitioner relies upon several decisions of the Honorable Supreme Court in this regard. Stop paragraph. Learned advocate representing the National Testing Agency produces a copy of the OMR. Give the copy of the OMR. OMR and the calculation sheet of the candidate in support of the submission that the candidate attempted all the questions on the day of the re-examination. Stop.
I'm also
Out
referring to
of the
page 54.
total out of the total 180
80.
questions, he obtained 155 marks. Stop. 65 questions were correctly answered, whereas 113 questions were wrong. Stop. It has also been submitted, paragraph D, that the petitioner, page 54,
54.
that the petitioner has already been intimated that he failed to produce the certificate from the chief medical officer / chief surgeon / medical superintendent of the government healthcare institution in the prescribed format. This possibly is not the right answer because this is only
Specifying that candidate as
yes,
physical limitation.
right. This will
is-
not do.
This is with
This is a wrong.
yes. This
এটা
is
লেখার দরকার নেই।
I have no. Only one submission is that she's not from physical disability, so this limitation is not.
How can you come out of the clutches of the benchmark disability?
My lord,
লিখুন, it has been submitted that as the petitioner is not suffering from any physical disability, comma, the 1 hour compensatory time may not be required for the petitioner, particularly because the candidate attempted all the questions. Paragraph. Upon hearing the parties, it appears that the information bulletin of NEET 2026 specifically mentions about the compensatory time that the candidate is to be provided if the candidate suffers from benchmark disabilities. Step. The admit card of the petitioner clearly specifies that he suffers from benchmark disabilities. Step. Paragraph. Let a report from the respondent number 5 be placed before this court as to whether explaining the reason for not allowing the 1 hour compensatory time to the petitioner to answer his questions. Stop. Release the matter on how soon? Today we are on the 12th. By 2 weeks, can you do it? By 2 weeks, can you do it?
2 weeks. My lord, they have to. My lord, they have to. I don't know whether they have served corner number 5.
Has you
Corner number 5. কোথায় আমরা এভিডেভিটের সার্ভিসটা কোথায়?
check up whether it has been served? এটা দিন তো ওনাকে দেখো সার্ভিস হয়েছে কিনা। Will you be representing?
No, I will not be present because that is school center.
আচ্ছা, টাইমটা বলছি। NTA Learned Counsel representing NTA shall revert with instruction as to how the petitioner can be compensated if it is ultimately found that he was not provided the compensatory time in accordance with compensatory time which he was entitled to in law.
It is delivered, my lord, I have checked.
All right. Release the matter on. What is the interim order that you are seeking?
But as of now, my lord, there are twofold things. My lord, your lordship may direct them to produce, my lord, the center video, the video of, my lord, the recording of the examination center to ascertain, my lord, whether he was given or not on the factual aspect. And one seat, my lord, has to be kept vacant in any of, my lord, the institutions.
Let a report come, then thereafter, my lord.
But otherwise, if there is a, my lord, a filling up of the vacancy, my lord, that will create another difficulty of an expectation of another.
Yet to start. Council even
Not started.
possibly council has not.
Then let the time be shortened a bit.
Lordship.
We are on 12th. By 21st, let it be done.
And the center video may be important, Lord.
Let me see. By 21st. ওই যেটা বললাম না, report from the respondent number 5, it will be 21st. আচ্ছা.
কোথায়?
The respondent number 5 is also directed to preserve the video recording of the examination center, of the examination hall, on the day and time of the re-examination held on 21st June 2026 until further orders. Stop. And release the matter on 26th of August.
26, my lord, I have some, I won't be at 27.
Liberty to pray for an interim order. In the event, Lord, it doesn't appear, Lord. That's the reason I was. Otherwise, my learned friend says that the interim order was refused. Liberty to not press for the interim.
It will be now. It will be open for the petitioner to pray for interim order if occasion so arises.
I'm grateful.
Lordship.
Sir, you have handed over this.
My lord, if the order is uploaded today in course of the day.
It will be uploaded. Order is to be uploaded today.
Lord, deeply obliged.
Much obliged.
The petitioners before your lordship, all are
Who is
impaneled.
your other side?
Mirror, I served upon all the Jaglane government period and all parties. Everyone we have served. Others,
State, Your Lordship.
Who is the answering respondent?
Mirror,
NTA.
state government authorities, all are answering respondents. Mirror, we have.
Mr. Menon was here. Just call him. The NTA is there.
Yes, yes.
I don't know. Please call Mr. Menon. He went out just now. Call him. He was appearing in the previous matter.
Well, the petitioners before your lordship, all are successful candidates in NEET. But they were all impaneled candidates. From tomorrow, the counseling will start. Now the petitioners all were OBC reserved candidates. That is why the state government did not allow them to take economically weaker section candidate. This is the state government's notification.
NTA is a party in this matter. Did you receive?
Lord,
The director, National Testing
Yes,
Agency.
below the mail. All were served by email.
NSIC. This is not NEET, but this is some other exam.
National Testing Agency was also served.
my lord, I will.
No, it's NEET UG, isn't it?
Neat.
This is NEET UG.
NEET.
Then it is the same examination. Take instruction.
Well, this is for conversion of the petitioner's status from the general category to EWS category
That
after,
means you seek reservation.
yes, to seat reservation
Hmm.
as economically weaker section, as they are no more OBC. They were all belongs to Muslim community. So after cancellation of OBC, only month of May of this year, the state government issued that yes, these are the reserved categories, others are not. So thereafter they again asked for giving them EWS certificate. Out of 6 petitioners, 2 has already received EWS certificates, other 4 has not yet. So this I have a twofold prayer. One is to direct the ADM alerts, additional district magistrates of Murshidabad and Nadia, to give us the EWS certificate at once. And
60 days is the time within which it is to be done.
my lord, the counseling is starting from 13 to 16.
Counseling is a different thing. They
The
also
counseling we cannot.
EWS cannot be given as a matter of course. It has to be inquired.
They applied earlier. They applied earlier.
Earlier
But
means when?
my lord, the petitioner numbers 1 and 4, they received petition around. My lord, the other 4 petitioners who were denied in 2025, they applied page 51 starting for 4.
Item 5, sir.
51 is an order of this court.
My lord, this was the rejection orders last year. Oh, 51 is the yes order of my lord. Thereafter 55 is the rejection order last year. And these
Where
year,
is your application?
yes, application is page 57, acknowledgement is page 58. They applied for in 1st July 26, after
When?
the notification was issued by the state government.
Notification was issued in May.
May. And
you apply in July.
July.
Why? You could have applied earlier if you wanted the certificate. Now you have to give them 60 days
first
time.
of all, from the remote corner, they will have to take instruction that this is really done. Because in the last year, that was refused. That you have an OBC certificate, so you cannot get EWS. In
Yes.
spite of my lord's order. My lord was pleased to pass an order in other case in 3rd July that both can go on parallelly, the OBC and the PWA, but there is no contrast distinction. But even thereafter, in the month of July, they refused these 2 pages, 55 and 56. They rejected, may be rejected for state EWS as they belong to ABC state category. So, my lord, once it was refused, this year after the state notification came in, sometimes were required from them, but in remote areas of Murshidabad and Nadia, they belong to the students. So, as and when they came to know, they applied for. The first one, 1st July, second one, 1st July, third one, 27 July, and 21 July.
22nd of July.
Yes.
And we are only on the 12th of August. Not even a month has gone. How can the court, because there is statutory time limit.
Then, my lord, the conversion, my lord, in 1 and 4 already received, 1 and 4.
Oh, whatever.
1 and 4 I have already received is EWS certificate. Lordship, kindly direct them to inquire and report before my lord regarding the other 4, 2, 3, 5 and 6 to give an EWS certificate, and my lord regarding others 1 and 4 to allow them conversion from general to EWS. 1 and 4 this certificate I have annexed. 1 and 4 certificate. My lord, that is at page 38. Their certificates I have annexed. Page 35 is the OBC certificate. EWS applied. Yes, page 46. 46 is the OWS certificate of petitioners 1 and 2.
At the time of filing the application, you did not mention your reservation.
At the time of application, 4 petitioners applied as general, as the OBC matter was pending. 2 were mentioned as OBC candidate, but after the OBC judgment has
What is the stand of
all
the
are
state
general.
after the
Lordship, we have to take instructions here, Lordship.
Category cannot be changed.
category cannot be changed, but the state has changed the category.
But I don't know under what circumstances it was, but normally once they apply for one particular category, the category cannot be changed.
The
Then
OBC,
on that
OBC
basis, my lord, the rank is declared.
yes.
Yes.
Now the OBC B is no longer there.
Yes, obviously.
OBC is no longer
Gone.
there.
Where do these people
It
fit
should
in?
be general.
It should be general, isn't it? Now they have applied to get benefit under the EWS category. Now whether EWS will certificate will be
That
given or
required, yes, separate.
Already
There is
got
a
it.
requirement of obtaining a certificate under EW, under the same.
if you want a reservation under EWS, you have to obtain a certificate.
Yes.
Now they have applied it only lately after the OBC B goes. Not even a month. Right? So without the EWS certificate,
But
you
Milord, 1
cannot
and
get
4
the
received
benefit.
it. 1 and 4. 1 and
Who
4.
has received is received.
And Milord, then they let them convert them also, if 1 and
That-
4. And Milord, that is also in their bulletin, which was issued only last night. And
Where is this conversion permissible? Please show.
Milord, Lordships, kindly, this is the bulletin I am given.
Last night.
Last night at 11:17, I got it, the state government notification. State government
Was it
notification-
published now or was it published earlier?
No, 11th August, the date is there. 11th August. It didn't just have
The state is
11th
still
August.
taking steps.
Yes, I issued this bulletin only yesterday, 11th August.
Give a copy to your learned friend. Tentative schedule for count. This is the counseling schedule.
Counseling schedules. So we'll
No,
start
no.
from
What
tomorrow.
about the conversion?
Conversion, Milord, in the bulletin, they have stated not conversion directly, but candidates who belong to EWS.
Yes, but you did not seek
Both
reservation.
of us already EWS.
You did not seek reservation at the time of filing the
Because
application.
then the state government did not allow us to go into EWS category on the alleged plea that you are OBC. My lordships, kindly consider they cannot cut us in both the ways. Once they are telling, that is the memorandum they issued, that the persons who are in SC, ST or OBC, they cannot claim benefit under EWS. And the other hand, when the OBC certificate has gone, they cannot say that now you cannot be converted in
State
EWS.
stand will
Sir, I
be
need to
required.
take instructions, Your Lordship, on this.
But
This has been
it's
served
not
yesterday
unfair
itself.
in case of the persons who applied for.
NTA, you
Well,
also,
yeah, I will take it.
in view of the change made by the state government,
Yes.
should a candidate suffer or not?
The difficulty is that, my lord, once it is, my lord, uploaded, the ranks, I mean, my lord, it cannot be.
I can understand.
Yes.
There may be
But
difficulties.
still, in lordship, there is a provision. There is a window open for 2 days before the examination. During that period, my lord, they can change the category if it is within time.
It is the notification. I have to check the dates. The notification came in possibly after closure of the window. So they did not have the option
Yes.
to change. Now OBCB is
Yes.
obsolete.
Absolutely. So whether they, yes,
Whether they can get the benefit of the EWS.
lordship.
General, they can always.
But the state government has to
Come back.
Yes.
But you also
Yeah, I will also take instruction.
take instruction.
Because our role is very limited. Contacting the examiner up
Up to that limit.
receiving application online, contacting
But the ranking, it is you who do the ranking. The ranking is done by you, isn't it?
Yes, ranking is done. Yes. Ranking is done by, I mean, it's made declared by UNTA, and it is now sent to ministry.
Sending is different. Now, if the category changes, then the ranking would possibly also change.
But once that window is closed, then we cannot. Our hands are tied. This is a difficulty.
Think it over.
Lordship. My lord, this I am very clear, because once a window is over, we can't do it. We can't help. Then they have to try next year. This is
You have to apply next year.
that is only option.
Either avail the benefit of general category
Yes.
or wait for another year for appearing in the examination. At least, sir, you take instruction. I do not know. The state has a separate
Yes.
seats, isn't it? Can't the
Yes.
state can give them some benefit at all? They
State has
All India quota 15%.
and
that
state
came
quota is
reduced.
85%.
But the
Then
state
quota
quota is there.
Yeah.
Yes,
Counseling is
85%.
done by the state.
State, and that will be done by tomorrow. Tomorrow, 13th, it will start. That is why I mentioned for early hearing, my lord. That 1 and 4, the EWS certificate they have received.
Start preparing for the next year or
Kindly
contest as a
consider
general
one thing.
category candidates. I do not think anything
My
can
lord,
be done.
the petitioners,
petitioner-
they will be deprived of their rights. My lord,
Participate-
kindly consider this.
Compensation. Nothing doing here.
My lordship, is it pending before my lord? It will be pending before my lord. And my
It
lord,
cannot be done.
my
Why
lordship,
I tell you, there are many candidates. This is not only 1 or 2 seats. Several candidates.
they have not come
who
before
are
my lord.
suffering for.
They have not come.
You want
If someone is waiting on the
no,
fences,
you want something.
my lordship,
Code
kindly
is not
consider.
here to generate
If
litigation.
somebody has some genuine difficulty, they can come. But those who have not come,
Participated in NEET UG 2026 under OBCB category.
4 under general category, 2 under OBC category. I have made that
Four parties in general category.
1, 4, 5, 6 is general category, 2 and
4, 5, and 6 general.
And 2 and 3 in OBC category.
2 and 3 OBC category. Why have they joined together in one petition? Everybody has a separate cause of action.
No, not Milord. Now everyone is general. At present, the same cause of action that everyone is general. Nobody is OBC. As of filing date of the petition, everyone is general.
Maybe, but then that does not give. There is no reason to file a petition jointly.
Milord, we have given everyone's court fees. Everyone's. I have given
Court
it.
fees is not the only thing.
Yes.
There has to be some reason as to why they should
We have
join.
given the common cause reason.
কি বললাম? Yes. After the state government published the notification.
My lord, may I take a lordship?
notification. Have you annexed the state notification?
Yes, my lord. Which notification my lord is referring about?
Last one where the OBC
Yes, my lord, that
was
is it.
taken away.
My lord, that is it. Page 44.
Notification on
18th May 26.
published notification on 18th May 2026, by which the OBC B category was struck down, comma, the petitioners presently intend to take the benefit of reservation under the EWS category. Stop. The petitioners applied for obtaining the certificate of reservation, and the petitioner numbers 1 and 4 received the certificate.
My lord, one received the certificate at page 46 on 28 July.
Which one? Petitioner number 1?
Petitioner number 1.
And petitioner
number 4 on 10th of August.
Very well. 10th August. No, date 1 and 4 received the EWS certificate, but the others are yet to receive the EWS certificate. Stop. The petitioners submit that despite possessing EWS certificate, comma, they may not get the benefit of reservation, as initially they disclosed their category as OBC B, which is no longer available to them. Stop. Prayer has been made to direct the authority to treat the petitioner numbers 1 and 4 as reserved under EWS category, and to direct the competent authority to issue the EWS certificate in favor of the other petitioners so that they may get the benefit of reservation under EWS category. Stop paragraph. The tentative schedule for counseling for the state quota in West Bengal has been published by the Director of Medical Education on 11th August 26. The first round of counseling
The first right-hand column. 11 a.m. of 13th August 26 till 16th August. First right-hand column.
Achha. The online registration for candidates qualified through NEET UG 2026 is due to start from 13th August 2026 and will continue till the 16th of August 2026. Stop paragraph. The petitioners submit that they may be provided the chance to appear in the counseling process. Stop paragraph. Learned advocate representing the state respondents is not ready with instructions. Stop. Release the matter on 14th August. Stop. Learned advocate representing the state respondents shall obtain instruction as to whether the candidates who have received the EWS certificate can be provided the benefit of reservation despite non-disclosure of the category of reservation in the application form. Stop. Instruction shall also be obtained with regard to the status of the application made by the petitioner numbers 2, 3, and 5.
2, 3, 5, and 6.
And 6. Regarding issuance of the EWS certificate. Have you followed what you
Yes,
were
Lordship.
supposed to?
I shall take the report of EWS whether it's being sanctioned or not. In permitted upon them, I will.
First is whether conversion will be allowed. They filled up the application form as OBCB.
OBCB.
Now, whether reservation under EWS will be allowed first, and second, what is the status of the application seeking EWS certificate is there.
I shall take them.
Let notice be served upon all the non-appearing respondents. Affidavit of service taken on record. এটা ফেরত দিয়ে দিন। শুক্রবার।
Grateful.
কি খবর ডিবি বাবু? ভালো আছেন তো? হ্যাঁ? Yes, next.
Grateful. The server copy by 2 evening. But if we get the server copy by 2 evening, we shall serve along with the notice.
You will get the server copy. টিফিনের মধ্যে করে দেবেন তো।
The petitioner has prayed for transfer on the ground of distance. It was rejected by the district inspector on the ground of being single, though it was forwarded by this
Microphone. On the ground of being
distance. On the ground of distance, the application was made back in
Yes, yes.
2021. Was forwarded by the school to the district inspector, but was rejected by the district inspector on the ground of being single teacher.
Single teacher.
Yes.
Where is the rejection?
So if I just could take your lordship to page number 23 once. On the serial number 4, if I just could take your lordship.
In 21.
21.
Single teacher. What is the position today?
Still, because there is a single post of mine in the school, so there cannot be any other teacher. So I just request your lordship if I just could make a fresh application, and my lord,
Make fresh application.
I'll do that. And my lord, I'll just request the observation of
Fresh application করতে হবে
Lord.
For transfer আর single teacher টা দিয়ে দেবেন. Previous application stood rejected in the year 2021.
Push. And my lord, if your lordship kindly, my lord, makes this observation that that with the if the alternative arrangement could not be found out, even in the case, that would be grateful. Otherwise, not the affidavit of service.
Monday matter was dismissed in front of us, both of us. I appeared. He said,
He was busy with other matters.
Yes,
The
yes.
client did not contact. There are reasons.
petitioner is not interested. Your lordship is absolutely
Yes,
right.
there are reasons.
And I was, my lord, nodding my head behind. Yes, petitioner. I'm so sorry, man. Grateful, man.
14.
No, I mean, petitioner নয়। But your lordship, no, আমি বলছি। Well, in this matter, I'm having secondary role, but somehow I have also been engaged as first aid also. And I have not received the state brief, and I think I cannot appear for both.
You are appearing for board?
No, board, I'm appearing for board.
Yes.
But state is the answering respondent.
Doesn't matter. Here the court is going to dispose of the matter. I do not know whether you can collect fees from two
That is
authority or not.
Collect from both sides. I don't want to. That is the reason I'm telling I will.
So take which one is better.
Then
You have a choice.
board.
Stay with the board. Yes.
This is the case of the petitioner paying for the higher scale of pay.
Yes.
This is the case, my lord. Now this issue is, my lord, the res intriga because the honorable my lord, single bench judgment was appealed before the division bench. The division bench has dismissed.
Which matter? Which
my lord.
judgment is
Malord.
this? Degi?
This is the division bench also, my lord.
What is the issue?
The issue is, my lord, the petitioner was appointed for the post of work education group with the qualification higher secondary examination and my lord, diploma in engineering. The petitioner scale of
Your application.
my lord, the scale of my lord, my application.
Has it been considered?
No,
Then
it has not been considered.
page, where is your application?
My lord, the first application, my lord, initially page 42, and that was my lord, thereafter, my lord, the
2013.
yes, my lord. Thereafter, my lord, the authority has my lord, asked to deposit some documents, and same was deposited. That is page 41. The district inspector of school asked to deposit some of the documents.
You approached the court earlier also, page 43.
Well, that was my lord, transfer.
Oh,
That was
not
transfer.
the higher scale of
No.
pay. Acha.
My lord, kindly page 42, pursuant to my lord, the order dated 7th August 2013, the school authority has my lord, deposited all the documents. And before that, well, the school authority has approached before the DI of schools for grant of higher scale of page 37. But my prayer and the fact is squarely applicable in the judgment which I have cited.
Tell me, 2013. We are in 26. Why will you not make fresh application? Please come. The petitioner seeks
Leave may be granted.
graduate scale of pay for serving as work education teacher in a school. Stop paragraph. It appears that the prayer for grant of higher scale of pay in favor of the petitioner was forwarded by the headmaster of the school to the ADI SE Howrah in May 2013. Stop. There is no response from the end of the ADI. No. The ADI responded in August 2013 requesting the headmaster to forward certain papers of the petitioner for consideration of the prayer, which the school forwarded in November 2013. Stop. Thereafter, there is no response. Stop. The petitioner prays for a direction upon the DI to consider his prayer for grant of higher scale of pay. Stop paragraph. It appears that a considerable period of time has elapsed after the communication was earlier made by the school and the ADI in 2013. Stop paragraph. In view of the above, now the petitioner, a learned advocate for the petitioner, submits that he would be covered by the decision passed by this court on 9th December 2015 in WP 8722 within bracket W of 2012 Keshav Ankure Bananta দেখে নেবেন versus State of West Bengal and others. Stop. The appeal preferred by the state challenging the judgment dated 9th December 2015 stood dismissed by the Honorable Division Bench on 23rd March 2017 in MAT 1846 of 2016. The State of West Bengal and others versus Keshav Ankure and others with can. Stop paragraph. As it appears that the matter did not proceed any further after the communications made in 2013, accordingly, the court is of the opinion that the petitioner ought to make a fresh application annexing all documents and serve the same upon the District Inspector of Schools, Howrah, SE Howrah. Stop paragraph. On receipt of the representation along with all supporting documents and the judicial precedent relied upon by the petitioner, the DI SE Howrah shall take a decision on the petitioner's prayer strictly in accordance with law and in line with the law laid down by the court in the matter of Keshav Ankure at the earliest, but positively within a period of 90 days from the date of submission of the representation. Step. If required, the authority may provide an opportunity of hearing to the petitioner for production of all documents in support of his claim. Step. A final order shall be passed and communicated to the petitioner immediately thereafter. Step. If the prayer of the petitioner is allowed, the necessary consequential steps shall be taken by the authority without any further delay. Disposed.
Only one prayer the petitioner or his legal representative.
Opportunity of hearing যেখানে বললাম না, petitioner or his authorized representative. Service cannot record.
অসাইনমেন্ট অর্ডারে গেছিলাম তো বলছে না এখানে তো আপনাকে অ্যালাউ করতে হবে।
That 15 I appear.
আমি দেখাবো হ্যাঁ বলে দেখাবো
I appear for the petition. But here, that I was initially appointed.
State who's appearing?
I appear for the respondent number 1.
My lord, I am for the respondent number 6.
That this is my affidavit of service.
Respondent
No,
number
teacher,
This school.
teacher in
school.
That the
Yes.
first.
Has Wakalatnama been filed by the school?
my lord, today, just on today.
Yes, please.
But I straightaway, I come to the representation, page 21. Well, in the representation made to the District Inspector of Schools, Howrah, and the ADI Ulbedia, I made the grievance that for the year 2011 and 2012, the incremental benefit has not been updated in my service book by the earlier school. But I was
Increment on account of
B.Ed.
B.Ed, higher qualification.
Yes. But I completed B.Ed in the year 2015. But I was appointed in 2006, 8th of April.
No decision taken.
No. Now I am placed in another school at North 24 Parganas. I was in Howrah. Now the school in Howrah, in which I worked till 2014, they did not update my service book. Now the case is, because of the non-updating the service book,
You cannot get the benefit
of 18 years benefit.
All right. Now show that you applied for updating your qualification.
Your lordship, can you have a look to page 24?
24.
This is the order of the DI. In 2018, my name comes at serial number 2.
Yes.
A restoration of annual increment. This is to inform you that loss of annual increment of the following teachers of his school between the period of 2013 to 2015 due to non-completion of the requisite training are hereby restored up to the period of 2015 as follows in terms of geo number so. Now, 2006 I joined. Annual increment 2013, 2014, 2015 that has been given. But the difficulty is the DA, B.Ed qualification which I have obtained in 2015, and I requested page 20. The earlier school.
You submitted in 2025.
My lord.
Yes, yes.
My lord.
My service book is with the school. But I did not know
Earlier school,
by the earlier school.
your service book is still written by
No,
you?
no. At present, but it has been sent.
Yes.
Yes, to the present school. Now the difficulty is until and unless 2011 and 20, just a second, 2011, 2012 is not updated by the earlier school, the incremental benefit cannot be given to me.
Why did you not intimate when you upgraded? Why in 2025 you are intimating?
I tell you, Lordship, it was made known to the school that my pay revision has to be done because I completed the B.Ed when I was the teacher of the school, and the school was very much aware. So I made this representation to the DI Howrah.
When? In 25?
Yes. Now, as the service book could not be sent to the present school, but there was an ambiguity of pay scale.
My lord, may I submit?
Yes.
My lord, the fact is that in 2006 he has came to the school, joined. There is a regulation, my lord. This is the regulation till 2012. That within 2012 you should have to make the B.Eds within 5 years from your service. Then your increment would have been come, or else your increment do not come. From 2012, he has transferred from my school to some other school. Though we have given all the document, but even then, we restored our record book. He has taken the record book from our school.
No, he says that he has taken his service book. That
My lord, service book as well as all the increment, all the statement with regard to his service, that statement he has also taken.
all right.
If your lordship direct, I can show your give your
It's all
lordship
right.
through
I
affidavit.
assume that she has taken it
My
up.
lord,
I accept it.
Now, my lord, it is not my responsibility to increase his increment. It is the come to the DI possession. And my lord, after making this, my lord, kindly come page number 21. The letter has been given, a copy has been given to my school also. After getting this copy, my lord, nowadays due to change of government, the governing body has been dissolved, and SI become the administrator of the school. We have making all the copies and send it to the administrator. He would have signed that, thereafter would return us, then only we can give it to the DI. Unless that, we cannot do anything else.
No, you do not have to do anything also because the petitioner is quite delayed.
And my lord, as per the regulation, he should have to do that B.Ed course within 5 years from the service. And that has not been done. What should we do?
Please come.
But the correction needs to be done from their end, because I obtained the
alleges non-release of increment on account of upgrading her B.Ed qualification. Stop paragraph. The petitioner was previously serving in a school at Howrah since 2012 and 2006. In 2012,
in 2014.
in 2014, she has been transferred to a school in North 24 Parganas. Stop. The petitioner claims to have obtained B.Ed qualification in the year
2015.
2015. Stop.
Page 18.
The petitioner submits that as her B.Ed qualification is not updated in her service records, accordingly, she is not getting the increment as per her qualification. Stop paragraph. A representation has been filed by the petitioner before the DISC Howrah.
Page 21.
In January 2026, the same is alleged to be kept pending. Paragraph. State no instruction.
Well, this has to be considered, because this is in the old era.
Paragraph. As it appears that the
Stated as-
petitioner's representation before the
Sorry, stated as state.
DISC Howrah is pending consideration.
Abandon দিয়েছে না? ও, তাহলে ঠিক আছে। Okay, তাহলে ঠিক আছে।
This one was 3.
Tell me one thing, why DISC Howrah? Why not 24
But
Parganas?
now I was in that earlier school, which was under the domain of DISC Howrah.
My lord,
See,
here
one
you should
minute,
have to- you should have to party both of
One
them.
minute. You obtained the qualification in 2015 and you got transferred in 2014.
My
So
lord.
why will Howrah do it?
My
But
lord.
I will, with my lord's order, my lord, I will make a fresh representation to the my lord, DI not 24 Parganas.
You-
My lord, both should be party over here.
Have obtained the higher qualification when you were in not 24 Parganas. And you made the representation before Howrah. Why?
It was the desire of my client, but I was not aware.
You did not advise her before
no, she-
filing the
he-
petition. You should have made a representation before not 24 Parganas and then filed the
With your lordship's order, my lord, I will kindly grant
Because
you
in
that
any event, this would get rejected on that ground only.
Acha. Likhun
he
to.
doesn't have any locus standi my lord, to consider.
It appears that the petitioner enhanced her qualification of B.Ed while she was in service in the district of North 24 Parganas. Stop. No representation has been filed by the petitioner before the DI AC North 24 Parganas.
My lord, no. My lord, your lordship, kindly it comes to page 18. It was a 2-year B.Ed course. So I got the degree in 2015. I started the course in 2013 when I was in that school, earlier school. Probably that is the reason.
And that is the reason you should have made both the DI's parties and both the schools parties. Acha. DI not 24 Parganas. Stop. The DI not 24 Parganas is not a party in the instant writ petition either. Stop.
ঠিক আছে, আপনার নামটা কি?
The B.Ed course
দিয়ে দিচ্ছি,
was of 2 years. Stop. The petitioner
আপনি জানালেন যে এক
started her course when she was in Howrah, but by the time she concluded the B.Ed course,
No.
she was transferred to North 24 Parganas. এই প্যারাগ্রাফটা আগে ঢুকাবেন, তারপর নিয়ে আসবেন। North 24 Parganas is not party. ঠিক আছে? The
leave may be granted.
in view of the above, the instant writ petition stands disposed of with the observation that it will be open for the petitioner to file appropriate representation before DISC North 24 Parganas. Annexing all documents in support of her claim. In the event such a representation is made, the same shall be considered by the DISC North 24 Parganas in accordance with law after giving reasonable opportunity of hearing to all the necessary parties and by passing a reasoned order. Step shall be taken to reasoned order. Step shall be taken to consider the prayer of the petitioner at the earliest. আচ্ছা, একদম উপরে একটা লিভ দেবেন তো নট 24 Parganas কে পার্টি করার জন্য EISC. You implead not 24 Parganas. বুঝে গেল? No time is fixed at the earliest.
My lord, in this aspect, what would we should do?
Don't do anything till a communication is made to you. You are not required to act. You give your presence at least.
Grateful.
ওই কাগজটা ওনাকে ফেরত দিয়ে দিন, ওটা দরকার লাগছে না। Yes, next.
Oblige, my lord.
Sixteen, my lord, I am mapping for the petition. Huh? My lord, this is my abuse service. Who appears for the West Bengal Council of Higher Secondary Education? নিচেই তো। The board, headmaster, secondary board. Council board, everybody is a party. What is the matter?
My lord, this is relating to, my lord, higher scale of pay that is turned down by the Commissioner of School Education.
Oh,
That is
Commissioner of
order
School
passed by
Education.
the, my lord, page.
You didn't serve the board?
My lord, I served, everybody I served.
Enter appearance if the board has been served. Page 36.
Page 38, page 38 onwards. My lord, page 39 by showing the control of expenditure amendment ordinance 2016, my lord, they rejected my claim. My lord, I am a honors graduate, subject in mathematics, appointed in the year 2013. And then after taking approval from the school authority as well as from the district inspector of school, I enhanced my qualification. And my lord, after that, I applied for the higher scale of pay. That was, my lord, forwarded.
All right. আসুন তো দেখি। The order dated 29th April 2024, passed by the Commissioner of School Education, rejecting the petitioner's prayer seeking higher scale of pay, is impugned in the instant writ petition. Stop. The legality and validity of the order impugned has to be decided upon exchange of affidavits. Stop. 6 weeks, 2 weeks, liberty to mention. Service is taken on record. Let this order be communicated to the non-appearing respondents. Next.
Grateful line.
17, I am for the. This is relates to higher scale of pay. The petitioner was pursuing prior to joining her service. Part 1 examination was held prior to joining.
Representation not yet considered.
I tell you, Lordship, after transfer, page 41, I made a representation to the present DI, not to Nodia, but the and school also forwarded page 45. DI communicated page 46. Where is the prior permission? But this has been settled by Adiluzzaman, Honorable Division Bench Judgment. I have annexed, my lord, the page.
All right, please come. The petitioner's prayer seeking higher scale of pay on account of enhancing his educational qualification. You filed a petition earlier also?
No, no.
Then what is this? Oh, this is your prayer. Acha, ঠিক আছে. Seeking higher scale of pay qualification was filed before the DI, AC Nodia, in May 2025. Stop. In July 2025, the ADI communicated to the school to provide a copy of the prior permission of the competent authority permitting the petitioner to enhance the qualification. Stop. Paragraph. Learned advocate for the petitioner submits that the issue in question is covered by the decision passed by the Honorable Division Bench of this court on 11th of February 2021 in Mat 825 of 2020, page 47. Muhammad Adiluzzaman. ঠিক আছে? Paragraph. As it appears that the prayer of the petitioner is pending consideration before the DISC Nodia, accordingly no useful purpose will be served by keeping the writ petition pending. Stop. representation consideration by the DI Nodia upon giving opportunity of hearing in terms of Muhammad Adiluz Zaman.
And
Within a period of
kindly melody at one line melody prior permission is not required. Because the part one examination was held prior to my joining. Now the after joining I took permission, study leave has been sanctioned by the board. I have annexed that.
The specific case of the petitioner is that the petitioner joined the course prior to joining the post in question, and accordingly the question of obtaining a prior permission does not arise at all. Study leave of the petitioner was duly sanctioned by the West Bengal Board of Secondary Education. বলে তারপর কনসিডারেশনের অর্ডারটা হবে ডিসপোজড 8 weeks বলেছিল হ্যাঁ representation
18 melody also pertain to higher scale of pay, but in this case my lord higher scale of pay has been allowed by the DI. Page 22, second last paragraph.
Leave without pay. You said a comments are successfully passed. The PG scale was allowed.
Allowed, my lord, on the basis of my lord, from
14th of July 2006.
Yes, 2016. 2016, my lord, April 2016, I received the salary on the basis of higher scale of my lord, the arrear has not been released by DI.
From 2006 till 2016, you have not received.
From
2006.
From 2006, my lord, till my lord, 2016.
You have not received. What were you doing? You received in 2000.
You also can see page 28. 28. A fixation has been made by you as per report 2019. Page 28, my lord, the school forwarded the arrear bill 2,12,250.
Please come. The petitioner's prayer for grant of higher scale of pay was allowed by the District Inspector of Schools. Higher to postgraduate scale of pay was allowed by the DISC South 24 Parganas with a order dated 18th of December 2015 with effect from 14th July 2006. Submission of the petitioner is that the higher scale of pay was, however, allowed from July 2016.
July.
From 1st of August 2016. Submission of the petitioner is that she ought
August
to be paid
2016, I have received
higher scale of pay with effect from 14th July 2006
to 31st July 2016.
Till 31st of July 2016. Now, 14th July 2006 till 31st of July 2016. August the school where the petitioner is currently serving has already forwarded to the ADI SE Diamond Harbour, South 24 Parganas necessary papers and documents for arrear salary of the petitioner to the tune of rupees 2,12,250. In April 2023, the same has not been acted upon by the authority till date. Paragraph. As it appears that the petitioner has already been found eligible to receive the postgraduate scale of pay on and from 14th July 2006, accordingly, the petitioner would be entitled to all arrears which have not been paid to her. Stop. The school has calculated the arrears and forwarded the same to the ADI. Stop. Paragraph. The instant writ petition stands disposed of by directing the DI, SE South 24 Parganas and ADI, South 24 Parganas, Diamond Harbor, to take immediate steps for releasing the arrear salary of the petitioner. At the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop. As the petitioner would be receiving the money, receiving her dues after considerable delay, comma, the arrear should be released along with interest, calculated at the rate of 6% per annum, payable on and from the due date till the date of actual payment. Supposed. Okay.
I am with the petitioner. The matters pertains to the higher scale of pay, my lord. The petitioner was appointed under the honors postgraduate category. After taking the permission from the DI, my lords, I improved my qualification. Subsequently, my lord, the prayer was made. My lord, no stay was taken. Writ petition was filed. That my lord, the impugn order was passed by the DI, my lord.
2020, it was rejected.
Yes, my lord.
Then
by referring the GO
whatever. Then what happened? Did you? Is this a challenge?
challenge, but my lord, I made a press representation after transfer the present school, my lord. It is rejected prior to the Utpal Gandhi Karan, my lord. In Utpal Gandhi Karan, my lord, the GO number 593 has no statutory force. And my lord also, my lord, the GO.
Then this has to be decided. Please take down.
Dedicated, my lord, your lordship. Kindly see the 593 once, my lord, referring the paragraph number 8. Kindly see, my lord, once. Paragraph number 8, my lord.
8.
My lord. They are referring the impugn order. Henceforth, no permission will be accorded for securing higher qualification for obtaining higher scale of pay to any assistant teacher and or any assistant teacher over 50 years of age serving any junior high school or any school respectively. I am 42 years now.
There may be other reasons. Actually, even though the rejection of the petitioner's prayer seeking higher scale of pay passed by the ADI SE Kandi subdivision Mushidabad on 13 November 2020 is impugned in the instant writ petition. AOAR. Yes, ma'am. Yes, your lordship.
State
Well, in this matter, I am for the petition.
Well, I am for the state, my lord.
All right.
Well, before going to records, my lord, just bear me. I am a approved, my lord, Group D, my lord, the lab assistant. I was appointed in the year of 2012. Thereafter, under the Utsosri portal, I made an application for transfer. Now, the recommendation was there, and the order of transfer was made by the board also. Now, I went to the school where I have been directed to join, but the school authority said that out of 4 posts, 3 filled up, 1 court case, and further said that in the order of transfer there is no clarity.
No?
Clarity.
Clarity.
Yes, I will show you, lordship. Thereafter, my lord, after being response by the school authority where I have been transferred, I made a representation to the board as well as the school of my Central School Service Commission for re-recommendation of the nearby school. That has not been added. Now,
So
your
right
lordship
now,
kindly,
right now you pray for re-recommendation.
at this stage, my lord, I am
Page
praying for
26 is the recommendation order.
Now, your lordship kindly come. Page first, your lordship kindly.
No, first and second. Page 26 is the recommendation.
Yes,
You were not allowed to join.
Join.
Case of 2022.
Case of 2022. And did you intimate the commission that you were
Yes,
not?
yes.
Where?
My lord, your lordship kindly come page 20. The response of the school. School has intimated me by
29.
page
29.
Page 29. Your lordship kindly come.
This page 26 is January 22. Page 29 is
page 29.
Also 11th of January 22 to the
Yes.
President Board appointment of Consideration Schools email to appoint Shamapada Maiti. You are Shamapada?
Yes, I am Shamapada.
All right.
Sampada, not Sam.
Shamapada, as there is lack of clarity against the vacant post. Uchosri.
Now, immediately, my lord, I made an
Read
application.
recommendation.
Next page, page 30.
What were you doing for so long? You filed the writ petition.
No,
when?
thereafter, your lordship kindly come page 32.
26. 32. What has
32.
happened?
My lord, in the month of January 2026, my lord, again I approached this authority.
Between 31 and 32, what have you done?
Kindly come page 28.
Yes.
Page
20 is incumbents shall join the respective assigned post within 3 working days.
No, if the school doesn't permit, then what remains?
Then 2022.
Where is the service upon the commission? Service upon the commission?
Yes, I have served all. I have served all.
Please find out anybody, either Miss Shupriya Dubey or Dr. Patro. Nobody is here? Just give a phone call. I'm passing it over for the time being. Give a phone call to either Dr. Patro or Miss Dubey.
At 2 p.m.
No, just now I'll take it up. Call, they'll be here somewhere.
Phone number, Jano.
They'll be here somewhere. You please call, they'll come. 21.
I'm 21 time.
Yes.
Malat here, Malat, I am praying for re-evaluation of my marks, Malat, that was 2025 candidate, Malat obtained
examination.
Malat higher secondary examination and Madhyamik examination. Madhyamik examination. And if your lordship kindly see for a moment page 47, Malat, what marks they given and what marks I am entitled to get. Malat page 47.
47.
Malat, this is Malat, if your lordship Gonit, Malat mode number 5, they give in Malat 4. Only 1 marks Malat cutting. Malat without any reason. If your lordship kindly see for a moment the answer script that was produced by me.
You mean to say you should be given full marks in all the questions?
Malat, no, all this question. Malat, two marks Malat I have to Malat Gonit and Itihas. Itihas Malat mode number 1 they given 0 in spite of Malat actual answer given by the candidates.
And what the court will do? The court will see whether it is answer is right or wrong.
Malat answer is right. They given Malat 0.
The court is not going to
Malat, I am praying before you.
He is a judgment, your lordship.
He is a candidate, and Malat, if your lordship kindly see their reply of my Malat review page 70, Malat even unmarked answer.
Madhyamik examination 2025. Stop. He applied for evaluation of his answer script.
Malat, rule doesn't provide revaluation, Malat, for a successful candidate.
Stop. The authority evaluated the answer script of the petitioner, and was any mark increased?
No.
Malat,
and
if Malat not evaluated, Malat,
instead
not
of
at all. No, Malat,
not at all.
System is if a successful candidate can only apply for scrutiny. So only scrutiny applied, no change. Scrutiny is computation of marks, no change.
Say evaluation, it will be for scrutiny. And there has been no change in the marks obtained by the candidate. Stop. The petitioner prays for re-evaluation of the marks. Stop. Show me the law. which permits.
No.
Wait.
I have judgment that
Not judgment. Show me the law which permits. Learned advocate for the petitioner is unable to produce any law which permits re-evaluation of marks of the Madhyamik examination in respect of a successful candidate. Stop. On the contrary, learned advocate representing the board submits that there is no law which permits re-evaluation of answer scripts of a successful candidate. Stop. Next. In view of the above, now, as the petitioner has failed to produce any law in support of the prayer made, accordingly, the relief sought for by the petitioner cannot be allowed. Stop. The writ petition fails and is hereby dismissed.
their statement, page 17,
Take down one more line. It has been submitted that the answers of the petitioner are correct, but the examiner did not give any marks to the candidate. Paragraph. It is settled law that the court, not being an expert body, ought not to pass any comment on the evaluation of an answer script by the examining body. Stop. The same is the sole domain of the examiner. Stop. Next.
I have two judgments of the
no judgments. There are many. If you have two, she'll provide 20 against you. 22.
Doctor, I am appearing.
Yes.
I appear for the state.
My lord, here is the petitioner is a disabled person. His father was an assistant teacher, retired assistant teacher. After his demise, after his father's demise, petitioner applied for dependent family pension. My lord, in this regard, petitioner came to know that he requires a legal year certificate from the district magistrate. That's why petitioner applied for that with relevant document. Relevant document means legal year certificate collected from the Ghatal municipality, as because petitioner used to reside there. Thereafter, my lord, the school authority headmaster has forwarded the same to the DI.
Did you get the legal aid certificate?
No, my lord.
Then what is your prayer over here?
My lord, unless and until the DI has directed the BDO to produce BDO Ghatal.
Inquire in the
but my lord, BDO Ghatal has returned with the remark that the deceased resides outside his jurisdiction. After that, the district magistrate forwarded the same to the Medinapur Sador BDO.
What to do, you please say, what is your prayer over here?
Oh, my lord, kindly direct the district magistrate to issue a legal year certificate.
No, that will you have to go before the residuary bench. Respondents to issue legal year certificate. Father of the petitioner to allow family pension. If that is your prayer, then how can it be done? Where is the document to show that the DI forwarded it to the BDO?
My lord, page 25.
To
the Ghatal video and next. Next, my lord, page 27. It was forwarded to the Medinapur Sador. And very next page, the reply of the video.
Yes, if you are not a resident of that area, then what can be done?
After that, my lord, finally,
has also given that you do not stay within the jurisdiction of Shodor. Where do you stay?
My lord, I used to stay at Kuspata at Ghatal.
Listen, I do not know. There are two authorities which says that you do not stay within the jurisdiction of either Ghatal or Shodor. Then?
No, I used to stay there at Ghatal. My father used to stay at Medinapur Shodor.
This is not the fact-finding court. In the absence of proper documents, the authority will not be able to act.
Kindly, Lordship, kindly have a look at page number 29, my lord. Thereafter, I made specific application before the district magistrate
Yes.
along with legal year certificate obtained from the Midnapur municipality.
Yes.
And thereafter, my lord, the district magistrate had forwarded it to the Midnapur Sadar block development officer, but till date, no answer given by the.
No, page 31, the DM sending it to the BDO Shodor, there is already a communication.
My lord, on the basis of this application, page number 29.
Shodor, with honor, I am sending here with two, as both the petitioners resides outside the jurisdiction.
My lord, in this representation, my lord, I have specifically mentioned that ওনার স্থায়ী ঠিকানা হাবিবপুর বড় আস্তানা পশ্চিম মেদিনীপুর, বর্তমানে আমরাও এই ঠিকানায় বসবাস করিতেছি, অর্থাৎ হাবিবপুর বড় আস্তানা মেদিনীপুর সদর পশ্চিম মেদিনীপুর. In this application, I have specifically
Please come. The petitioner seeks pension on account of being the disabled son of a deceased school teacher. Stop. The application of the petitioner seeking family pension on the ground of disability cannot be disposed of by the authority for want of a legal heir certificate. Stop. Learned advocate for the petitioner asserts that the father of the petitioner was residing at Habibpur, page 31. Boro Astana, PO Mendipur, PS Kotwali. Stop. The office of the district magistrate has communicated to the block development officer Midnapur Shodor to state as to whether the petitioner would be entitled to receive the legal heir certificate as sought for. Stop. There is no reply from the end of the BDO Midnapur Shodor. এই যে ডিএম পাঠালো ভিডিও কি ডেট হচ্ছে 1st June 2022, page 31, paragraph. Learned advocate representing the state respondents is directed to obtain necessary instruction from the respondent numbers 3 and 4 as regards the legal heir certificate to be issued in favor of the petitioner. Stop. Release the matter for further consideration on 9th of September 2026. Written instruction from the aforesaid respondent shall be produced before this court on the adjourned date. Next.
Great, my lord. I have see the
Yes,
affidavit of
service is
service.
taken on record.
Further, sir. Great.
23.
But I am for the petition.
Yes.
This is a matter concerning correction of the year of birth, Lord, in respect of Lord, a CBSE student, Lord. But I have appended Lord, the document to show Lord, her year of birth was recorded Lord, in the records of CBSE due to oversight at 2003. Whereas Lord, the actual date of birth is 2002. So Lord, so far as the year of birth is concerned, Lord, I am aggrieved and I say that it should be corrected to Lord, the correct recording of the year of birth at 2002. The Lordship will kindly come to Lord, the admit card, the date of birth is recorded to be Lord 2003. Page Lord, sorry, Lord 17. Page 17. জিজ্ঞাসা যাদবের জাজমেন্টটা বার করে রাখা. Then your lordship will kindly turn to Lord, the next page, Lord. This is also Lord, reflects to be 2003. Whereas Lord, the certificate of birth at page 19, Lord, it says Lord 2002. But it was Lord contemporaneously issued in 2002. This Lord, the birth certificate. Then Lord, The Aadhaar card.
It is the candidate who fills up all
Yes, my lord, this
details.
was, yes. It was my case, my lord, when I applied before the school at page 29, my lord, I'm sorry, my lord, at page, my lord, 26, it was stated, my lord, error due to handwriting of student during the form fill up.
Where
Page,
it is, where
page 26.
26.
The 26 is nowadays, my lord, it is required to be routed through the school from which she appeared.
Error due to handwriting of student during form fill up.
Yes. This was, my lord, at page, pre-page, page 25. This was, my lord, the format.
Correction to be submitted by the principal.
Yes, that has been submitted by the principal, my lord, to the CBSE. My lord, that is at page 29.
In 2025.
Yes, because, my lord, she discovered this.
Discovered this. You appeared in the CBSE
2019.
examination
2019.
2019.
Yes.
From 19 to 25.
But nowadays, my lord, the limitation period is not there, my lord, after the Supreme Court judgment.
I just want to know that
Yes.
what were you doing from 19 to 25?
I only could discover it when I was not getting admitted to Presidency College. My lord, that I have also annexed here. At the time of admission in the Presidency College, my correct year of birth is there. Well, my correct year of birth is 2002. My lord, it is not that I'm gaining age, I'm losing age, my lord. That
I understand, but then I want to know what were you doing?
my lord, it was due to oversight. But the school says that we have verified with the document at page 29 and asked, my lord, the CBSE, my lord, to consider it. But as of today, my lord, the CBSE has not considered it.
All right,
But
let me hear.
and my lord, I'll be relying upon the judgment of the Supreme
Wait
Court.
1 minute. Let me hear.
But the board had sent a mail to the school asking to furnish certain documents.
Let me see.
That was in 2020, 19 March 2026.
The school
And
has
not responded.
not responded, but they have not provided, they have not furnished the original date of birth certificate. Without that, because this is a Xerox copy,
Yes, it's a
so they
photocopy.
wanted to verify the
I'll
original.
give it on the next.
They wanted to see the original, and there are some other.
It has to be routed through the school.
Lordship.
It has to be routed through the school. Can a copy be given to you and you can forward? Or it has to go through the school?
No. What has happened? They have furnished a
Photocopy.
Now, school board has, because there is a prescribed procedure, my lord, to get the date of birth changed in the records. Now, as per that procedure, my lord, we had written the letter asking for, calling for these documents.
Is the school a party?
Yes, my lord. Yes, they have been served, my lord. I have got the
Nobody is appearing.
evidence of service.
If they approach the board through the school with
Yes.
these original documents, I think board will consider in accordance with the rules.
I was just wondering whether the original, if the candidate gives to you, can it be done?
My lord,
No,
that
it
is
will
not
not be proper.
No, that will
It
not be
should
proper.
go through the
It has to
school.
be routed through the school.
Yes, please.
That is my lord. May my lord, I will the rules. 69
The
2 3.
petitioner appeared
Request-
in the CBSE examination 2019. Stop. Her date of birth as recorded in the admit card is 13th May 2003. Stop. The petitioner states that her original date of birth is 13th May 2002. Stop. The petitioner noticed the error very recently at the time of getting admission in the graduation course. Stop. The petitioner has filled up the format for correction of date of birth and submitted the same to the principal of the school in April 2025. Stop. The school forwarded the request of the petitioner to the board in May 2025. Stop. Allegation of the petitioner is that the prayer of the petitioner is yet to be disposed of.
Lord, interrupt, my lord. One more mail was, my lord, was sent to the,
Sent,
because
and learned
they-
advocate representing the
recent
submits that the board communicated over email to the school authority for providing the original
documents.
school records and supporting documents for effecting necessary changes in the date of birth of the candidate. According to the board, comma, there is no response from the school. Stop paragraph. Learned counsel for the board relies upon the rule. Is this a rule?
Yes. Examination bylaws. Bylaws.
Achha,
Oh,
bylaws.
this is also.
Bylaws
Examination
of
by-
the Central Board of Secondary Education, 69.3, relating to correction of date of birth. Stop.
This 2018.
2000.
That latest one. Jika Jadhav.
This 5 years bar will be there, I see.
Yes, that is a difficulty. But
No, that has been taken care by the Supreme Court judgment. Lord, I'll just hand over
Yes.
Lord Dexter.
It's
I think Mr. Menon will agree to that.
Yes,
But Lord, your Lordship will kindly.
Going into it right now.
because there is a.
Because in
that-
terms of
yeah,
Jika Jadhav, Lord, let them consider.
I have.
Let them
No, but
check
Jikya
up.
Yadav may not be applicable. That is a case of change of name.
Doesn't
No, not only that, not only that.
First,
Yes.
you reject that it is beyond 5 years, then we'll go to that issue.
Yes.
It has, that stage has not arisen as of now.
Okay.
Acha, ki bolam?
Jika
Bylaw 69.3.
Page
Hmm.
194.1.
Correction of date of birth.
94.1.
Top paragraph. None appears on behalf of the school despite service. Stop affidavit of service is taken on record. Just check whether it has been received.
Lord, I'm handing over.
You've
Lord.
checked up.
I've checked up.
It's received.
Yes.
ठीक है, चलो, despite service. Stop. Acha. As the board contends that the school is yet to forward the original documents required for effecting the changes, accordingly, the school authority is directed to take immediate necessary steps to forward all documents as per the email communication made by the board on 19th March 2026, followed by reminder on 12th August 2026. Positively, within a fortnight from the date of communication of this order. Stop. On receipt of all documents from the school, the board shall take a decision in the matter. Shall consider the prayer of the petitioner for correction of the year of her birth in accordance with the prevailing laws at the earliest. Stop. The matter is made returnable on 28th of September 2026 for recording further updates.
Lord,
I'm grateful, Lord.
Lord, instead of 28th, can it be on 27th, subject to your lordship?
27th of September is a holiday.
September, oh, my lord. I was August.
No, it's September. 2
Oh, my
weeks
lord.
the school
lord.
is going to send. Then you
My
take
lord.
a decision.
Lordship.
So I have kept that
No, I heard.
period.
Everybody has come.
Huh?
But I'm grateful. Lord.
Yes.
Everybody has come. Item 20.
Yes, I'll take it up.
Thank you.
Degi password. Item 20. Did you get a copy? You've gone through it?
Yes.
A recommendation was made, page 26. Recommendation was made in January 22.
Yes, madam.
And immediately on 11th of January, page 29, the school intimates to the board that the petitioner could not be permitted to join. Petitioner seeks re-recommendation. Take steps.
My lord, in that case, my lord, it appears that the post in question was possible due to a litigation was pending. But by this letter, the headmaster is saying that already we have applied for supporting document on 10th of January 2022 to the DI for prior permission or clearance. It appears that after the clearance, the petitioner may be allowed to join.
Very well. You communicate with the school. If the petitioner is permitted to join, he will join.
That DI may be directed to intimate us whether they have given any clearance or not. Because this letter of 2022, my lord.
Why don't you communicate with the school to inquire as to whether the DI has given a communication or not? Because it is your recommendation.
Yes, my lord.
It is not that petitioner is going there on his own voluntarily. You recommended the petitioner to a school. The school is not permitting. So you should follow it up with the school and inquire as to whether all papers are all right or not so that the petitioner can join. Please come. The petitioner was recommended for transfer as a non-teaching staff to a school.
Group D, lab assistant.
January 2022 non-teaching staff যেখানে বললাম না ওখানে ব্র্যাকেটে গ্রুপ ডি
lab
assistant ঠিক আছে relying on the aforesaid recommendation comma the petitioner visited the school for joining stop the petitioner was however denied by the school to join citing reasons which the school communicated to the board by communication dated 11th January 2022. Stop. The petitioner immediately applied for re-recommendation. Stop. No steps have been taken by the authority till date. Stop. Prayer has been made to direct the commission to take necessary steps to either permit the petitioner to join the school where he has been recommended or to re-recommend the petitioner to some other school where he can join.
In nearby school. Paragraph.
Nearby school where
Yes.
he can join.
Paragraph 11 I have stated.
Paragraph. Learned advocate representing the commission and the district inspector of schools are directed to revert with positive written instruction with regard to the next course of action that may be taken in this matter. Stop. Release the matter for further consideration on 9th of September 2026. Written instruction from both the aforesaid respondents shall be placed before this court on the adjourned date.
But it does not appear that the petition has been served on the commission, my lord. In that case, my
Give a copy. Give a copy.
Yes, yes. My lord, may I play? In place of 9, it may be 10th. My lord.
10th. Not 10th. No, 10th is a Thursday. I won't. 8th it can be.
8th.
8th. 8th tarik. 8th of September. As none appeared on behalf of the commission in this matter, comma, the court requested Miss Shupriya Dubey to enter appearance on behalf of the commission. Stop. Let her engagement be regularized by the commission.
I
need to password.
No, my learned friend says, my lord, without state it cannot be done. That's why I'm.
Take a file. 24.
No, I'm for the petition.
Hmm.
No, my lord, may I tell you also the facts, your losses. My lord, I have to take
Tell
you
me
lot.
the prayer first. Then I'll go to the facts.
Prayer, your losses will not
First
probably.
SLST 2016.
Prayer, your losses at
State
page
service is affected
20.
by the entire process is being discussed.
My lord, in short, I tell your lordships, after the Supreme Court judgment, I have been allowed to join the earlier post, whereas now that has been not given effect to by this order,
By this order,
by
which
this
order?
impugned order.
Impugned order.
My lord, your losses, my lord, if I place it, then your losses, my lord, go to the impugned
Show
order.
the impugned order.
Impugned order, your lordships, at page
46.
46 and
DI.
40. Yeah. It's not the impugned order as such, but 46 and then your lordships.
First 46. নাহলে বোঝা যাবে না।
Tushanta Kumar Deo has joined assistant teacher 25 on reinstatement. However, his history of his previous school, how the incumbent worked for only 2 days and left the school without any resignation letter and no employee ID was created for payment of salary. He was submitted his unwillingness to join the post of the chairman secretary in Malda as a tarike. The matter was not informed to the school regarding second school. No, he had to. Date of joining is at the. When you lost your job, you were in Noihati Ananda Swarup High School.
Yes.
You were previously serving in Banarhat Balko
Yes.
Porimal High School.
Only for 2 days.
2 days.
Kindly. My lord,
But then there was an appointment letter.
exactly. Recommendation. No, that's why kindly allow me to place it. I stood first.
You had an appointment letter.
Appointment, recommendation, joining letter, everything. The case is that after 2 days service, I didn't go to the school. Now I sat for again. I stood second. This time I was given appointment letter, recommendation both. But ultimately Supreme Court quashed it. I'm untainted.
Thing is, you left the job in 2013. SLST was in 2016. So there was no continuity in job.
But I tell you, losses. There is no continuity, but they have again recommended me.
Who?
The commission.
Has
I
recommended-
joined and I'm serving now. But because of this I'm not getting selected.
Wrongly recommended.
But even wrongly. My lord, I tell you, losses, it's not wrong.
That has been said that at the
it
point
has
of
been said.
recommendation, the matter was not
That's the whole
taken to
problem.
office by the school at that point of time.
Now I tell you, losses. My lord, if your losses go to the order of the go to the order of the Honorable Supreme Court, paragraph 47. Kindly have a look at this. Paragraph
Please show. Is it annexed?
Bar code 47. Then I will take your losses, our High Court judgment. Paragraph 47.
Yes.
Some of the appointed candidates who do not fall within the category of tainted candidates may have previously worked in different departments of the state government or with autonomous bodies. In such cases, although their appointments are cancelled, these candidates will have the right to apply to the previous departments or autonomous bodies to continue in service with those. Malad, it doesn't limit or restrict that whether persons 2 days served or 3 days served. I am not asking before losses, continuity, seniority, nothing. Kindly have a look under this.
Suppose you do not ask. The court's order records that the seniority and other entitlements will follow. Which means
your losses
that
can mold it. Your losses in the fact.
sort
No,
of
no, no, no.
licensing
No, no, no. Your losses. No. It's your losses molding your losses in a sense that I am not asking on my own asking. Now kindly have a look at this judgment of our High Court. What happened? Here, the petitioner was selected in as primary teacher. Appointment letter was given. He did not join because in the meantime he was selected in the higher secondary. He went there. Ultimately lost like me. Now this court says even he didn't join, he should be appointed.
all right, the dates will matter.
I tell you, losses. If your losses wants to distinguish it, always your losses will have hands.
No, that
but
is
kindly have a look
different.
at paragraph
But
10
let
on.
me understand whether it is in the same line. Distinguish comes later.
Kindly
You
have a
have
look.
to say first that it is similar.
Exactly, madam. I can't say same, but similar. Kindly have a look at paragraph 10. On careful reading of the order dated 26th April 2024, it appears
that on a particular fact situation, the coordinate bench found it fit to fix the cut-off date, stipulating two conditions. First, candidate must have been called for interview process in connection with 29 selection process for being appointed as primary teacher, and second approach should have been made to this court by filing writ petition. It was decided if these two conditions are fulfilled, in that event, particular candidate needs to be appointed as primary teacher in a school in the district of Malda. But this selection process, therefore, 2009. Your losses kindly now. In the present case, fact situation is totally different. But the petitioner not only participated in the pre-interview process, but also he was selected and appointment letter issued in his favor on 28 September 2021 in connection with his participation in 2009 selection process. When the appointment letter was issued, petitioner was working as an assistant teacher in higher secondary school. As a result whereof, he chose not to join the post of primary teacher based on appointment.
Is the commission there? Commission is not there. It is commission who has recommended your name.
Again, your lord, that's your losses will have that at your losses at page. And I joined.
What was the requirement letter? Because all that
Page 43.
there.
Page 43.
Let the state and the board, state and the commission come.
Lordship.
Then we'll see what is to be done.
Very outset, I said state is required.
Has fresh service been given?
Fresh service given. But again, I have to serve, I know, my lord, because it will go to GP. Nothing will happen. But any event, your losses, Director, we give them the notice for the.
None appears either on behalf of the state respondents or the West Bengal Central School Service Commission. The presence of the aforesaid two respondents is extremely vital for effective adjudication of the instant case. Stop, let fresh notice be served.
This is Dubey is there.
Upon the
Dubey is not here. He was there, Malay matter.
ought to be here.
You have served.
You served.
Again.
Give a phone call at least. But state you didn't. State you didn't.
Government
Then
leader.
reservice also.
Service done.
Then you inquire who has been allotted. No allotment. No allotment. Allotment cannot be done so soon.
Allotment the allotment can be done on the same day.
You have to have a pool of councillors.
It's coming
Full list is there now. Full panels are there.
Is coming, your lordship.
Appearing.
No, I have told him about this matter. So he said, okay, I'll appear. But he is in court number 30, he's coming.
Doesn't matter, his junior is here. So his appearance and junior's appearance, I take there. But then I need effective presence over here. Instruction ought to be given. Let fresh notice be served upon the. Or what I can do, I can pass it over instead of.
Pass it over for the day it will happen. But I think Mr. Bhattacharya also will not be able to.
Having the instruction of this, your lordship. I have just informed him this is the matter.
Effective will not be.
Fresh notice dite bolun and released on next Wednesday, 19th.
But twice he stood first and second. There should be some leniency. There must be. It's not that he's tainted all.
That the previous service, my lord, he never received any salary, only worked for 2 days. His service was not approved also. And your lordship, as per rule 11, as per the rule, your lordship, if a person does not work for continuous 5 years, deem resignation.
25.
Item number 25, my lord, I appear for the petitioner.
He has not been engaged.
At 25, I appear for the school.
School. Who's for the petitioner?
I am for the petitioner, my lord. I am for the petitioner.
Yes. What is the matter?
My lord, this is the second round of litigation.
Yes.
On 6/2/2026, my lord, at page 60, your lordship passed an order for granting pension for cooperating writ petitioner, headmaster, as well as the DI should cooperate in the among them so that the pension is released and the PPO is issued in favor of the petitioner. My lord, what has happened, my lord, is thereafter, my lord, I have cooperated. But in the meantime, my lord, with the headmaster, my lord, all papers were shown to the DI. What DI has done is, my lord, since I have made my option date as incorrect, that was my inadvertent mistake. That is why, my lord, DI is taking that I have not filled up the option form and it is taking the date as 1/1/2016. 1/1/2020.
State, who's for the state?
But the recent order passed by the DI at page 62 is under challenge.
State.
State কোথায়
I
যাচ্ছে
require the presence of the state.
This is March.
But we have served a fresh. I think my junior is there.
Fresh service has made.
Fresh service is not done.
It has been made.
No, no, my lord, fresh service has not been.
Not been made.
Fresh service.
Why?
Upgrade করেছিস notice দিস নি?
I was.
At the time of upgradation, please make fresh service. It has not been served.
But I tender apology.
And so let fresh none appears on behalf of the state respondents. Stop. Let fresh service be made in the office of the learned government pleader. Stop.
When the last writ petition was moved, but the same thing happened.
List 19th of August.
19th.
Next Wednesday.
Great.
For the state lordship.
It is to compassionate appointment, my lord.
Who was the teacher?
Laboratory attendant.
Laboratory, who was?
My lord, the other, hey, sorry, husband.
Husband.
Husband, no, death certificate, annexed P1.
Death.
And my lord.
2022. When is the application
My lord,
made?
lordship, my recommendation was also made. Lordship, can come to page 19, my lord.
Yes.
My lord, this has been taken resolution. And on 5th January 2023, my application has been forwarded to the DPI by the principal. Application
Yes,
is
state, what is your
next
submission?
Lordship, I'm submitting on instruction lordship. It's a government aided college lordship.
It's a
college, aided college lordship. And in case of aided college, there is no scheme for appointment of a employee.
on compassionate ground.
They are referring a memo, Labor Department memo. In that memo, lordship, it is itself stated that employee, government employee. But this is an aided college lordship.
Lordship, kindly see.
Another memo lordship 690 EDN, where it was specifically requested to Director of Public Instruction not to forward any proposal for compassionate appointment in the absence of a particular scheme.
One minute, I have to
I'm referring to a judgment. I'm referring to a judgment lordship. Bhavani Prasad Shankar lordship. 2007.
Please give.
Volume 4 SCC.
In several cases,
Yes, where is the scheme pursuant to which your application will be considered?
my lordship, kindly see. Only.
Come prepared.
No,
Are you ready?
one second, or let me take up tomorrow, my lord. Tomorrow, my lord.
Next week. The petitioner seeks compassionate appointment. Stop. Her husband. কি হচ্ছে বাইরেটাতে? In harness on 30th April 2022. Stop. The widow applied for compassionate appointment immediately thereafter. Stop. The college forwarded the prayer of the petitioner for appointment on compassionate ground to the Director of Public Instructions
On 5th January 2023.
on 5th of January 2023. Stop. The same is alleged to be kept pending. Stop. Learned advocate representing the state respondent submits that there is no scheme pursuant to which appointment on compassionate ground may be allowed in favor of a dependent member of an aided college. Stop. The department notification relied upon by the college at the time of forwarding the prayer of the petitioner to the DPI is meant strictly for government employees and not in favor of government aided colleges. Stop paragraph. Learned advocate representing the petitioner seeks time to revert with proper instruction in this matter.
There is another statute.
Which Calcutta University statutes? What statute?
Instead of that, my lord, I have taken another statute. It will be 4, I have taken 1. Sorry, ma'am.
Next, 19. Yes, service ticket.
2011, volume 4 SCC, page 209.
Yes, next.
That's 27 I. But here,
State.
Yes, 58,
Yes.
I am for the state.
Yes, what is the matter?
that this is a matter taking compassionate appointment. It's a unique case where my father, who was appointed in a school, if your lordship kindly have a look to my father's appointment at page 17. I was appointed in 2017 purely, my father was appointed in 2017 on a purely temporary basis in the post of Group D in so-and-so.
Prior to being made permanent, he expired.
No, he expired, he joined at page 18 and thereafter, if a lordship turns to page 1919.
Yes.
In 2024, in a reply to the RTI, the office of the district magistrate is
See, your father expired in 2020. Show me that he was made permanent prior to his death.
This is not regarding that. This is regarding COVID. The COVID scheme.
Show the COVID scheme.
Yes. That is why I said it is a page 20. Kindly have a look to.
Yes.
The doctor's certificate.
Yes.
I observe, last but one paragraph, I observe the sign and symptom of the patient that may be suspected case of COVID.
All right.
So I advise the patient for admission to the hospital. This was on 26th of April. Then page 22, he expired on 27th of April. But before the COVID test is report comes out, he expired. Now, the case of the petitioner is that if your lordship can turn to the notification. The notification dated page 25. 12th of August 2020. The state government has galvanized the entire state machinery and mobilized so disposal to combat the situation arising of the outbreak of COVID-19, a large number of COVID warriors comprising permanent employees, contractual employees, casual employees, hired workers, volunteers of the state government, urban, rural, local bodies, public sector undertaking, and other statutory bodies under the state government working so. Then, now, third paragraph. Now,
why go? You read thereafter.
Yes.
Who are working day and night, risking their lives to provide urgent medical treatment. You do not.
And other supports. Yes, I have done that.
What support system have you?
I'm showing to you. And other support services to affected population and to enforce restriction to ensure that the containment of the pandemic. Many of those frontline workers have themselves been affected by COVID-19 and unfortunately some of them so. Now what my father has done is, if your lordship kindly have a look to the appointment of my father. Page 17.
Yes.
But in 2017, the pandemic was not there. Then, if your lordship kindly have a look to page 19, 19. It certified that late my father's name appointed Group D through District Magistrate Bakura was present in the school from 2nd of March 2020 to 7th of March 2020. Thereafter, for the month of March and April, he was present. This is also to certify that on 23rd of March and 2nd of April, was engaged in arrangement of office work, ringing bell, collection of attendance, and distribution of midday meal rice and potato distribution in the period of lockdown pandemic, along with other present staff, as per the order memo number so of the DI. So, my lord, I was discharging the duties during the pandemic period. Page 19. My lord, got it? Yes.
Yes.
Now, my lord, in terms of the order of the DI and the additional district magistrate, because the midday meal was,
has your application been considered?
But my application has been rejected.
Sure.
Yes. My lord, can you turn to the rejection order, page 37.
Is the state ready with instruction?
Yesterday, my lord, I received the brief, my lord. I've taken instruction from department, my lord. My lord, kindly state to come to page number 37.
Come. Are you ready or not? This is what I want to know. I'll come. Are you ready or not?
Ready, my lord.
Ready. All right. Yes.
Page 37. Is the
37.
impugned order at 28th of July 2025. But this is the state project director. But this is a type copy. If your lordship kindly turns to page 54.
No, I can read. You say what is there.
Yes. But my claim has been rejected.
Yeah, on what ground?
Kindly have a look too.
What is the ground for rejection?
4.
4.
The certificate of the joint BDO Ranibad, Bakura, as annexed in your letter dated so clearly mentioned that no COVID pandemic situation certificate, that is midday meal distribution, was issued from this office. The relevance of this certificate is not understood and with regard to the claim of the petitioner, whose father is claimed to have died due to COVID-19. Certificate of Dr. Ajay Kumar Nath so as annexed in your letter dated so regards that it may be suspected case of COVID. So I advise the patient for admission in the hospital for COVID test. It is not known whether the deceased was further tested or not. If not, then why DEO, without verifying the fact and document, has merely forwarded, because my name was forwarded to the department, the application to this end without applying his mind. I will place that. From the letter of the applicant received by the DI, Office of the District Magistrate Bakura, paragraph 1 reads that the decision passed by the District Inspector of Schools, the application of Sadhana Shahu, my mother, may not be taken into account as per GO number so is not acceptable by us. So when one district officer under the school education department has already rejected, not accepted the prayer, then why the DEO, being also an officer deputed under the school education department, has simply forwarded it to us, and that too without any specific remark? From the above observation, it is
Please show 12th August 2020.
Yes.
GO 2413.
But this has not been given to us. This has not been supplied to us.
Did you seek for?
But
You filed the writ petition in 26. You have annexed the impugned communication, which is July 2025. You didn't seek for this. Under the Right to Information Act, you could have collected it.
But I have not sought for, but this was never given to, this is a mere communication, because this has come after my case was forwarded.
The state project director says that it could not have been forwarded because earlier it was rejected.
Yes.
So the earlier rejection is not there. The memo relying on which it's rejected.
Nothing has been given.
What is the, yes, what is the submission?
My lord, kindly see page number 37, my lord.
Yes.
With regard to his earlier reference dated such and such, the district education officer SSM being the appointing authority of the employee as PB SSM at district sub-district level may clarify. 1. whether
not
late
read.
Madhav Chandra Sahu, father of,
Sir, please don't read. Tell me what is it?
he is not a permanent employee. His father was not a permanent employee, my lord.
His father was not a permanent employee.
Employee, my lord.
All right. There is a COVID notification scheme which the petitioner relies upon. Will the petitioner get the benefit of that scheme or not?
My lord, kindly, the death certificate of the petitioner father, my lord, there is no cause of death.
COVID, the cause of death was not written at that point of time. Immediately at the outbreak, the person expired.
Even, my lord, doctor prescription not
The
clear.
school has written that he was engaged in the distribution of the midday meal articles and everything.
Totally temporary basis, my lord. His father was a totally temporary basis. He is not permanent employee.
Yes, but he died of COVID. Will he not get the benefit of the COVID circular? Take
I
written
take instruction, my lord.
Please come.
consult এখানে hands নেই দাদা।
The petitioner seeks compassionate appointment.
Instruction নিয়ে।
Stop. His father was a temporary employee of a school. Stop. He expired on 27th April 2020 during the COVID outbreak. So, learned advocate for the petitioner submits that the prayer of the petitioner ought to be considered in terms of the notification number 2413-F within bracket P2 Mr. Bhattacharya, this 12th August 2020, you didn't get. You didn't get.
I got it.
You just now said you didn't get. You do not know what is there.
Yes. Yes.
Paragraph 6. Application of Sadhana Shahu may not be taken into account as per Geo. Huh?
I just missed it.
You missed it.
I missed it. Really. It's my fault. I was in a motion to.
In a motion, and you missed it.
No, the question which fell from your lordship, I missed it. Otherwise, I submitted everything. I have shown to your lordship everything.
What is it? This 2413 is already annexed to your writ petition.
Yes.
Right?
Yes. I have not suppressed anything.
No question of suppression. Na.
I just missed it.
2413-F within bracket P2 dated 12th August 2020. Stop. Paragraph. The prayer of the petitioner has been rejected by the state project director, Paschim Bongo Samagro Shiksha Mission. Nobody is appearing for the mission, isn't it? Acha, mission. Did you serve the mission?
Yes. Mission is a party.
Usually, Mr. Rai Mukherjee, Honorable Justice Rai Mukherjee appears for the mission, Your Lordship, but after his engagement by telephone have been mentioned on all matters regarding PBSM just to take time for a particular period. So therefore, there's no engagement from on my behalf also. Therefore, I'm not appearing as well. So with regard to the mission, that is the status, Your Lordship.
Acha.
You know what I have.
Yes. Stop. Paragraph. The petitioner relies upon a certificate by the teacher in charge of the school dated 11th November 2024, specifically mentioning that the father of the petitioner was engaged in arrangement of office work দরকার নেই। Engaged for distribution of midday meal rice and potato distribution during the lockdown period, along with other staff. Stop. The work statement showing that the father of the petitioner was on duty is also available. Stop. Paragraph. The respondent number 4, Paschim Bongo Samagro Shiksha Mission, is directed to file a report disclosing its stand. Stop. Let the report. Now, instruction shall also be obtained by the learned advocate representing the state respondents. As regards the prayer of the petitioner. Stop. Release the matter for further consideration on 7th September 2026. Now make it on 8th. 8th of September 2026.
Great.
Let this order be communicated to the non-appearing respondent.
Much obliged.
Great.
Abher মধ্যে next date বলতে হবে না next
বল পুট্টু আড়াস বল ঠিক আছে school. My lord, I am for the petitioner, my lord. The petitioner, my lord, is a assistant teacher. He, my lord, was appointed on 7th December 2024 as a teacher in charge. And he has discharged his duties as teacher in charge till 31st December 2025. After, my lord, resignation, my lord, he has handed over the charge to the present teacher in charge. My lord, but he has not received the documents and my lord has not completed the charge. I make a complaint before the DI, page 48, my lord, it is pending before the DI. My lord, kindly come to first, my lord, page 36. This is the 36. My lord, this is the charge handover and takeover. So Lord, I have signed it in the top. This is the second part of the teacher.
Have you joined any other school?
No. I am the assistant teacher in this school. I am working as an assistant teacher.
So
But
you
my
have only handed over the
Uh,
charge
is
at
it-
TIC.
TIC, but TIC has not completed the charge handover, takeover charge. So, my lord, any allegation may come, my lord, and any responsibility in future. That's why, my lord, it should be completed by the teacher in charge. So, I make a complaint, page 48, my lord, kindly see, my lord, for a moment, page 48. But my grievance. So, my lord, TI to take a decision, my lord, whether
Why DI will take a decision? First, you have to show where is your appointment as TIC.
my lord, the come. Page, my lord, page 14, page 14. At present, my lord, the said teacher in charge also, my lord, change.
To the president approval as teacher in charge, Nitai Chandra Das, 80.
Yes,
And this is in 2025.
25.
Show me the document to hand over charge.
My lord, on words, my lord, I have given the documents, all, my lord, on and from page, my lord, page 20 onwards. He has received it, my lord, he
Who
signed
has
that.
received it?
My lord, this is seal. This is, my lord, the teacher in charge seal. My lord, page 20.
Who directed you to hand over charge? What was the requirement of handing over charge?
Because, my lord, I have resigned from my post. So,
Which
my lord,
post?
from teacher in charge.
Where is the resolution adopted by the managing committee of the school
the-
that they
in their
accepted
hand-
your resignation?
Before the school, my lord, I have been removed. So, my lord, I am
So that you have been removed.
my lord, I compelled, my lord, I have stated, my lord, I compelled to resign by the managing committee.
Listen, once you say you resigned, next you say you have been removed. You have to take a stand.
No, my lord, resign means, my lord, I am compelled to resign. So, my lord, they have taken resolution behind my back. So, you resigned it, my lord, I have resigned.
Certain things are not automatic. Your approval as teacher in charge came from the DI.
My lord.
Where is the document to show that there was requirement of either resignation or handing over charge? Something.
So, my lord, previously,
There was a direction you choose and you resign.
resignation has to be accepted by the managing committee.
Yes.
Resolution.
Yes.
And direction should be
No,
passed by the managing committee. Page 43, my lord.
my lord, the previously when
I'm for the private correspondent number 6, my lord.
8.
school,
School authority.
My lord.
yes.
The teacher
My
in
page,
charge, my lord.
page 43, my lord.
Okay.
When I took
Is
charge,
that
my
teacher
lord,
in charge?
when I teacher in charge,
Number 6.
present
Number
teacher in
six,
charge.
present. I have also resigned from my post right now in
Present.
June 2026.
Why?
There is some discrepancy that has been pending, and
That is my lord.
discrepancy only.
There is some discrepancy
My
pending.
lord.
It's very
It's a fund
disputed. Manage this total. I have the report.
My lord,
I have come with the report. Although it has, this issue has not been mentioned, but the condition is very difficult, my lord.
There is another rectification pending, my lord.
It's
that is
very
expected
difficult to maintain the management. It is a fit case for appoint an administrator. My lord, kindly go to the report, my lord.
Why don't you appoint? Who's stopping you? You are the DI. You can always take steps if the school is not being managed properly.
We have received this report from the ADI and we shall take necessary steps.
In connection with the above noted subsidy are unlikely from the petitioner appointed.
Who resigned?
No,
Who resigned?
regular
খারাপ অবস্থা মারামারি হচ্ছে
teacher is the managing committee.
নিজেদের মধ্যে মারামারি সেই জন্য বলছি এসব গন্ডগোল এসে বলবো আমি রেসপন্সিবল কি হয়েছে আপনার জানা হলো না 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 একজন এরকম মক্কেল ছিল জানা হলো না Authorized entry, criminal intimidation की नहीं
The SI is already acting as the administrator.
No.
Yes, this is what your report says.
functioning as the SCS. Managing out to me, all schools of actually administrator appointed. আমরা তো এরকম নাই
Where certain prime ratio of any other permanent she or other has expired. Further, notice the regional procedure. Your name is Nitai Chandrota.
Presently, the name of the petitioner is not available in this report, my lord.
In order to resolve this issue and further administrator.
Presently acting as administrator. Leakage into what? Administrator appoint him.
Is it a school or something else is going on over there?
May I suggest one thing?
Yes, please.
Direct the district inspector of school that what steps he has taken after receiving this report from the AI. A direction should be given to the district inspector of school.
Please come. The petitioner was appointed as teacher in charge of a school by the District Inspector of Schools, Secondary Education, Murshidabad in January 2025. Stop. The petitioner tendered his resignation in December 2020.
24, Malad, appointed on 24, resignation 25. December 24 and
January 2025. Huh? No,
7th December
7th December 2024 by the কি বলি কি দিয়ে শুরু করলাম on 10th January 2025 with effect from 7th December 2024. Stop. He tendered his resignation on
3rd December 2025.
3rd of December 2025. Stop. Allegation is that despite submitting his resignation, comma, the process of handover of charge has not been successfully done. Stop. The petitioner has made a representation before the DI SE Murshidabad on 30th December 2025 and alleges that the same has not been considered till date.
And Mala 6th February 2025 also, 26 also. Last page, 48.
All right.
Last page.
Achha, next. Learned advocate representing the state respondents has obtained instruction from the DIS SE Murshidabad dated and assigned on 9th July 2026, which mentions that there are several issues in the school for which a detailed report was called for. A detailed report has been prepared and handed over to the DI. The report is annexed with the instruction forwarded by the DI. It appears that the team which visited the school for inspection experienced extremely unfortunate, disturbing and intimidating situation inside the school premises. The team was of the opinion that there is an atmosphere of fear and unrest. The paragraph দিয়ে লিখুন না ওখানেই লিখুন যে the team found that there was unauthorized entry into the TIC's room, criminal intimidation and threats, false allegations, defamation and mental harassment has also been alleged. Paragraph. It appears from the aforesaid report that the atmosphere inside the school premises is not conducive for teaching young students. The District Inspector of Schools, SE Murshidabad, is directed to take prompt necessary steps to restore normalcy in the school. Hearing of the writ petition stands adjourned till 9th September 2026. A report from the DI disclosing the follow-up steps taken on receipt of the inspection report from the team shall be placed before this court on the adjourned date. The DI may also consider appointing an administrator in the school. Now, it appears from the report that the SI of schools is already acting as administrator of the school. Necessary steps shall be taken by the administrator also to address the issues mentioned here and above. Let us see what happens.
My lord, I beg to appear on behalf of the petitioner. My lord, affidavit of service may be kept with the record. My lord, there, my lord, one issue I should point it out before your lordship, that this pertains to, my lord, the regularization of pension with regard to, my lord, fixation of the date from when he is his service will in service he will be eligible. Now, my lord, there has been an observation of the coordinate bench that I need to point out your lordship, because there a cutoff date has been, my lord, mentioned. Now, my lord, it is my duty to point it out whether, my lord, your lordship will take this matter, because it's a fresh matter, because pursuant to that direction, no step has been taken by the DI. Now, my lord,
It's not a contempt application.
No.
This is a writ petition.
Yes.
And there is no problem in taking it up.
Yes, my lord, but it was
Show me
my
the
duty
dates.
to show, my lord.
Show
And
me the date.
in the meantime, what happened, my lord, the Honorable Division Bench has also, my lord, in the similar circumstance petition, has, my lord, কত নম্বর page না?
Please.
23. 2023. My lord, kindly takes up page 23 first. This is Chinmoy Kumar Mondol and others, wherein, my lord, the present writ petitioner was also a party. This was the first writ application moved.
What is the immediate relief that you are
My
seeking?
lord, immediate relief what I am seeking is pursuant to the direction of the Honorable Division Bench, the DI may take a fresh call considering the observations made to, my lord, fix my date of service, joining of service.
No, you said that the court has already decided it.
The court has already decided it. My lord, let me point it out. That's why, my lord, I need to place it. ওটা নয় দিদি দাঁড়ান আমি দেখাচ্ছি এক মিনিট My lord, kindly takes up page 47 first. This is an appeal preferred by the state of West Bengal against one
The appeal got dismissed. You tell me what is your prayer and where from the DI will come to a decision.
Yes, then my lord, kindly takes up page 44, my earlier writ petition. The order passed in
Yes.
earlier page 44. Now, my lord, the ordering portion is at page 46.
Right.
Accordingly, the writ petition is disposed of. Now the direction part comes. The
Release
fourth
the pay and
respondent's
allowance
director is such and such to release the pay and arrear pay to the petitioner for the period of January 1, 2014 to March 31st, 2016 with interest of 6%. This is one part. This is the ordering part. Now, my lord, there has been an direction to release the gratuity. That's in the second paragraph of the concerned page. And now, my lord, this part, what I am, my lord, trying to place before your lordship, the concerned respondent will sympathetically consider whether any pensionary benefit can be granted to the petitioner counting his service from December 24, 2010, when the order was passed in the earlier writ petition. My lord, this was not, my lord, it was not adjudicated. This was, my lord, a mere direction upon the DI to sympathetically consider my case. My lord, this was not binding upon the DI per se. Now, my lord, the DI was supposed to take a decision on that. Now, my lord, in the meantime, while we are awaiting this decision of the DI, the Honorable Division Bench, in the matter of the similarly circumstanced petitioner, 5 petitioner moved the writ court for regularization. Regularization was made. State preferred an appeal against that. The appeal of the state was dismissed. The Honorable Division Bench held that the cutoff date will be from the date of initially joining of the service in respect of one writ petitioner. Now, my lord, I was not party in that appeal, where, my lord, the appeal was dismissed. But in the respect of same school, in the respect of similarly circumstanced petition, the Honorable Division Bench has observed that the cutoff date will be from the date of the initial joining of the service. So, my lord, I was only praying for, my lord, despite this observation being made by a coordinate bench, whether, my lord, DI can, my lord, pass a fresh decision, because there is no decision passed.
When is the original date of your engagement?
My lord, kindly takes up page একদম প্রথমে আছে page 18.
Tell me the date.
31 January 1982.
And the court directed counting your service from 2010.
2010.
And you accepted it?
My lord, that was, my lord, that was an observation made that you may kindly look into this issue. And that was, my lord, subsequently in another, my lord, I cannot better the cases. This is what is on record. So, my lord, this is what, since the DI has not taken any decision, if, my lord, while taking a decision, these new circumstances has occurred, probably that is not a ground for review even, not a contempt. My lord, I'm in a peculiar situation.
Show me that you are in service from 31st of January 1982.
My lord, I can only, my lord, rely upon the direction passed by this honorable court in 2010. If your lordship kindly takes that.
Were you a party over here?
Yes, yes. The cause title is there, my lord. Your lordship kindly takes up page 21. Number 5 is Shamul Mondol, the petitioner before your lordship. And in the cause title itself, I have been described as an
Unapproved organizing assistant teacher.
and 5, no, my lord, I am the unapproved organizing non-teaching staff.
What did the court direct?
And my lord, if your lordship looks into the division bench order, Chinmoy Kumar Mondol was the my lord, teaching staff in the same writ application. My lord, may I please the court's direction in 2010? Though it was ultimately decided in an contempt application, my lord, the DI approved. In view of the above,
I have read that. What does the contempt say?
my lord, after the contempt, my lord, their services were regularized.
Contempt order in page 33?
My lord. That goes on to the last. There is a series of orders.
Oh, there is a series.
In page 41, my lord, can come.
Your matter is in 41.
Yes, my lord, this is the entire writ petition. Lordship will kindly see the number WP 14073 of 2010, where I was the petitioner number 5.
Where is the petitioner number 5's and the petitioner number 5 with effect from 1st of January 2014?
Yes.
Date of upgradation in the vacant. When did you retire?
Retired is on 2024. My date is. No, I can't.
What do you want? Qualifying service.
There may not.
Service period.
Yes, that is there obviously, my lord. If your lordship goes by the direction initially passed of regularization, from there, my lord, if my service tenure is conducted, it's more than 10 years.
So you get the pension.
Yes, I get
now
the
you
pension.
want.
Now the fixation of the pension, if I, my lord, if I can substantiate my.
Already got it. Yes.
My lord, kindly consider the order at page number 44, order dated 1st December 2022, my lord. My lord, kindly consider page 46 once, my lord.
24th of December 2010.
My lord.
24th of December 2010.
2010, not 2010, my lord, 2022.
Page 46.
My lord, 46 is, my lord, page, it is order of, my lord, 1st December 2022, my lord. It starts from
Yes,
page
sir.
44.
Page 46. You want to rely upon
First paragraph and, my lord, third paragraph.
Third paragraph, 24th of December 2010.
Again, my lord, that, my lord, it is not the mandatory direction upon the concerned respondent, my lord, to take the decision of only to consider sympathetically that part, my lord. Now, my lord, the petitioner is trying to, my lord, take the advantage of the judgment passed by the honorable division bench.
In his matter, not
He's
in
not a
some.
part. He's not a party to that proceeding. He's not
There was a previous writ petition and a contempt
contempt, my lord. Thereafter,
Where the-
regularization was done.
where the his approval was made with effect from 1st of January 2014.
2014, my lord.
In the writ petition, it was mentioned that they are in service from 1981
81 or 82, my lord.
whatever.
Yes, my lord.
Right.
Yes, my lord. They have accepted this order, my lord. 1st December 2022, my lord. They have not challenged this order, my lord. Kindly consider that aspect, my lord. My lord, they have accepted this order, my lord. They have received, my lord, the retirement benefits from, my lord, January 1st, 2014, my lord, to March 31st, 2016, my lord. And my lord, and also, my lord, these honorable coordinate bench, my lord, considered this aspect and directed at page 46, my lord, the concerned respondent will sympathetically consider whether any pensionary benefit can be granted to the
Has
petitioner.
any decision been taken?
Well, that I have to take instruction. My lord, then they have not filed any application for contempt, my lord. There is direction. They could
Maybe
have
not contempt. The fresh
well,
petition is
I can take instruction on this.
Yes.
Since there was a direction from the honorable coordinate bench,
I
my
don't
lord.
think you can go back to
Yes,
82 and 81.
I am not going on to that, my lord. What happened is, my lord, probably a contempt would have not been a proper because, my lord, there was no adjudication of the issue and there was no direction.
But
it was
consideration order was there, my lord.
So, my lord, if they have not considered that order, my lord, by respectful submission can be revisited pursuant to the, my lord, latest developments which has occurred. And they can take into account the divisions bench directions, which, my lord, in respect of the same school, same petitioners, group of petitioners,
Please
My
come.
lord, whatever the situation is, they cannot claim from 81 or 82, my lord. Because they have accepted this order. They have not challenged this order, my lord.
The petitioner claims to be in service since 31st of January 1982. Stop. His service was, however, approved by the DI of Schools, SC South 24 Parganas, on 5th July 2016, with effect from 1st January 2014. Stop. Petitioner has since retired from service and is obtaining pension, receiving pension. Stop. Submission of the petitioner is that the authority ought to take into consideration his past service. Stop. Learned advocate for the petitioner relies on the order dated 8th April 2024, passed by the Honorable Division Bench of this court in Mat 1675 of 2023, with Can 1 of 23, Can 2 of 23, State of West Bengal and others versus Chinmoy Kumar Mondal and others, wherein under similar circumstances, in respect of the same school, the court directed the authority to take into consideration the service rendered by the candidates since 1991. Acha, ota na, to acknowledge, ki bola? To take into consideration the past service rendered by the employees. Stop paragraph. It appears from records that the petitioner approached this court on an earlier occasion by filing writ petition being WPA number 24238 of 2019, which stood disposed of on 1st December 2022. Wherein the court directed the authority to sympathetically consider whether any pensionary benefit can be granted to the petitioner, counting his service from 24th December 2010. Stop. Admittedly, the DI is yet to take a decision in this regard. Stop. Learned advocate representing the state respondents is directed to revert with further instruction in this regard. Release the matter for further consideration on 16th of September. Stop. Letter written instruction by the DI be placed before this court on the adjourned date.
Great.
Next. Did you serve?
Yes.
Fresh service
Fresh
also?
service has been done. Here's my affidavit of service.
Yes.
Lordship, in this matter, the petitioner was an assistant teacher in Beltola Girls High School. She retired in February 2025, 20th February 2025. But till now, she hasn't received her pension and other retirement benefits.
Why?
Your Lordship, Lordship, there's no formal order as to the reason given by the DI as to why pension has been withheld, but only verbally they've communicated that the death certificate of the husband has not been provided. Now, what has happened, Your Lordship, is that my husband has been missing since 2002. And due to that, I have filed police complaints, and police has passed, after investigation, had given a report that this person is not to be found. I've done publication, newspaper publications as well. Despite that, there's no trace of my husband to this day. Therefore, in my service book, notes down in the initial stage that my husband's name is Mr. Joydeep Ghosh, but subsequently, because of him being missing, my pension applications after that say that I'm separate. So therefore, I'm at this stage, I cannot produce a death certificate of this missing person. Therefore, I believe for that reason, my pension is not being, there's no other formal reason given. This communication also with regard to the husband and their death certificate, also a verbal communication given by the DI. And as a result, my application, my e-pension application is pending and still before, and the application says on the portal, it says that the PPO has not been generated.
Please come.
In the morning, I inquired if any allotment has been made. I believe there's no allotment yet made on this writ petition, Your Lordship.
None appears on behalf of the state respondents despite service. Service is taken on record, affidavit of service. The petitioner was appointed on 1st August. When were you appointed? 1st August?
1st August 1999, I was made permanent. Probationary since 1987. 99, I was made permanent. 1st August
97 is your date of appointment.
Date of appointment.
And he's superannuated
28th February 2025. The Lordship will find that
28th of February 2025. Stop. He is not getting her terminal dues, allegedly because she is unable to provide the details of her husband who went missing since 2002. Do you have children?
I have one daughter. Her name is there in all the pension papers as the nominee.
All right. As the teacher has superannuated more than a year back, accordingly, she would be entitled to receive her terminal dues in accordance with law. Stop. The DI SC Kolkata is directed to file a report before this court addressing the issue. Stop. Release the matter on 16th of September 2026. Stop. Let an intimation be served upon the DI SC South 24 Parganas and in the office of the learned government pleader.
It.
Yes, Your Lordship. But after the petition.
Take down one more line. In the event the report is not placed before this court on the adjourned date, the DI shall remain personally present on the next date.
Extremely good.
Yes, next.
At position, Lordship. Now for the petition. My Lord, this is, my Lord, regarding, my Lord, my non-selection or putting me in the disqualification list regarding me to be a general category candidate in spite of me being an orthopedically handicapped candidate in the SLST 20. Yes, SLST 2025. So, my Lord, I have, after my Lord mentioning, I have also once again notified my learned senior Mr. Bhattacharya, Nilanjan Bhattacharya, about this matter.
Yes. What is to be done in his absence?
But my urgencies was.
Is the counseling going on? Or
Yes, it is still going on, my Lord, but it is, they are supposed to complete it by 31st, but still.
That will be extended. But then,
My Lord, if I just could take your Lordship, my Lord, the merits of this
the
matter.
absence of the other side, I will not.
My Lord,
You could have called him up in the meantime.
Well, I yesterday called, but I just once again my served a mail in this meantime.
I keep it on Friday. আমরা SLST নিচ্ছি না? I keep this matter on Friday when the SLST matters. 21 তারিখ। 21 তারিখে তো অন্য বড় মামলার হিয়ারিং আছে, কিন্তু এটা
21st my lord is that
বলে হবে না? Notice upon Mr. Bhattacharya, let
One
us see
second.
what happens.
One second. Grateful.
Under the heading upgraded motion.
Grateful.
Upgraded motion. Yes.
I beg to appear for the petitioner.
Lord, I am appealing for a stay.
I'm the second report. Let me Mrs. Bhattacharya.
Was appointed in the year
Mhm.
2005.
Voted.
Thereafter, my lord, in 2022, she was transferred to another school. But the previous school, my lord, the previous school is not updating my service book and it has not been my lord, handed over with my present. As a result, thereof, my lord, I am suffering. The previous school, what the previous school has done on ROPA 2019, but I have submitted option for ROPA 2019. Not the pay fixation for other teachers were fixed with effect from 1st January 2020. But in my case, my pay fixation has been done from 1st February 2020.
1 month delay.
1 month delay. As a result, thereof, my pay fixation has not been properly done and it was not recorded to my certificate. But repeatedly, I made representation to my earlier school that kindly update my service book.
And what is the reason for not updating it?
I do not know. On several occasions, I asked my teacher in charge.
Did you intimate the DI?
Yes, ma'am.
Sure.
EDI হচ্ছে page 32, 33.
Page 33, if you don't kindly have a look, my lord. ADI, I have intimated.
Okay, page 33.
ADI of the school where my earlier ADI of the concerned division, my lord, jurisdiction where my earlier school is situated.
43, 35, 36.
Yes. Is the school a party?
Yes. Respondent number 8,
6, 7 records.
7 and 8.
Nobody is appearing possibly. Paikpara High School.
Yes.
It's the earlier school.
Earlier school.
And this Sarsuna High School is the present school.
Yes.
Any instruction from the DI?
Yes, my lord.
Let me see.
Already instructed not to.
Please come. The allegation of the petitioner is that her pay has not been fixed by the school where she was serving.
1 minute, I am
Namely,
interrupting, my lord.
Paikpara High School.
My leave records has not been also properly updated in my service.
Stop. The leave records of the petitioner has also not been properly recorded. Stop. The petitioner has been transferred from Paikpara High School in June 2022 to Sarsuna High School. Stop. The paragraph in view of non-updating the school records, the petitioner's pay is not being fixed properly. Stop. Prayer has been made to direct the school to update her service records. Stop. None appears on behalf of the school. Stop.
My
There is a
PF
service.
account has not been transferred also, madam. My
PF.
PF account.
আচ্ছা, যেখানে grievances গুলো আছে সেখানে her PF account has also not been transferred to her present school. Where is your service book?
Service book is lying in with the previous school.
In her entire service book with all records is lying in the Paikpara High School. Actually, learned advocate representing the state respondents has obtained instruction from the DI, SE Kolkata. wherefrom it appears that the ADI Howrah and the Spikepada High School was directed to look into the grievance of the petitioner. Stop paragraph. As none appears on behalf of the school, offending school. Accordingly, the court cannot decide the issue conclusively. Stop. The district inspector of schools
DI Howrah.
AC Howrah is directed to take up the issue with the headmistress.
Teacher in charge is there. Respond number 8.
No headmistress, teacher in charge of Pikepada High School. And try to resolve the issue. Stop. Let an opportunity of hearing be granted. Let take it in Likhun. The DI SC Howrah is directed to grant an opportunity of hearing to the petitioner and the representative of the Pikepada High School. Stop. Release the matter for further consideration on 16 September 2026. Stop. An updated report from the DI-SC Howrah shall be placed before this court on the adjourned date. Stop. Let this order be communicated to the non-appearing respondents.
Ready.
I am for the petition.
State Nadi school. Oh,
An affidavit of service, and we had served a notice also after mentioning.
The AG.
AG Bengal.
Have you challenged certain rules?
No, not that AG, Malad.
Not that.
Pension profit.
But the
Auditor General.
Accountant General.
Yes.
Malad, I retired from the post of headmistress on 31st of January 2025.
Yes.
Till that, Malad, pension has not been released in my favor, although PPO has been issued. And the reason is that the school is not forwarding the no liability certificate. The president of the managing committee has issued a no liability certificate in my favor. In fact, after visiting the school, Millard, the teacher in charge also provided me with the with a copy of the no liability certificate, but it's probably not in the format, and the school is not forwarding to the DI's office, and thereby the pension is not being paid.
Who is for the school?
Malad, I am for the school, Malad.
Yes, please.
Malad, I am for the teacher in charge of the school, Malad. The allegation is, Malad, mainly against me. Now, Malad, what has happened in the instant cases, Malad? Upon retirement, Malad, the petitioner here in Malad did not submit any documents, Malad, to the incumbent teacher in charge. We wrote, Malad, to the teacher in charge, to the erstwhile, Malad, the teacher in charge, Malad, numerous times. You submit a supply as the copy of the documents. We wrote, Malad, to the DI that these are the documents. Malad, only one thing, Malad, just Malad.
What is the way out?
Kindly, Malad, considers one aspect. Malad, I wrote to Malad the DI. The DI called a meeting in his office. Malad asked both the parties to come. Malad, the petitioner did not, Malad, go there. Therefore, Malad, as of now, Malad, it's in a stalemate condition, Malad. I do not have any and there's, Malad, a financial allegation, Malad. Although, Malad, until and unless I get all the documents, Malad, I cannot, Malad, speak upon that, Malad. There's a
They will get the documents and then manufacture the allegations. That is the
No, absolutely, Malad. I've written to Malad the DI, Malad. He cannot, Malad, interject me in this manner, Malad. I've written to the DI specifying, Malad, the allegation, specifying a particular check number, specifying a particular amount. Malad, the letter has also been forwarded to her. Malad, as of now, Malad, this is the stalemate situation. Kindly, Malad, I've got all the documents with me, Malad. Kindly seize. Kindly, Malad, text this up. Only, Malad, a bare perusal of this, Malad, to serve the purpose.
Before Malad, that Malad, page 16 of my writ petition, this person
retired from service as headmistress of Gopalpur Girls High School within bracket HS on 31st January 2025. Stop. Though PPO has been issued in her favor, but the disbursement of the dues cannot be made as the petitioner is unable Now, as the school has not forwarded the no liability certificate to the authority. Stop paragraph. The petitioner submits that no liability certificate has been issued in her favor by the president of the managing committee
At page 25.
and also by the
Teacher in charge also.
teacher in charge of the managing committee.
At page 48.
But as the no liability certificate is not forwarded by the school to the treasury officer, comma, the money cannot be disbursed in her favor. Stop paragraph. Learned advocate representing the school submits that the petitioner has not submitted various documents which she ought to have on superannuation. Stop. The school made repeated communications to the DI.
The DI also
A
called a meeting.
hearing was also called. Also, no, a hearing was called by the DI, but the petitioner was absent at the hearing. Stop. Till the issue is resolved by the DI, comma, it may not be possible for the school to forward the no liability certificate. Paragraph none appears on behalf of the state respondents. Stop. Admittedly, the teacher has retired in January 25 and is yet to receive her terminal dues despite issuance of the PPO on 21st of April 2025. Next. It appears that there is certain issue with regard to handing over of documents to the school. Stop.
And before
Paragraph there, the district inspector of school secondary education Durgapur is directed to call for a hearing of the representative of the school and the petitioner and try to resolve the issue. Stop. Next. The matter is made returnable on 16 September 2026. Stop. An updated report shall be placed by the learned from the DI by the learned advocate representing the state respondents. Stop. Let this order be communicated to the DI SC Durgapur and also to the learned advocate representing the state respondents.
grateful. GP officer দিবি direct DI को দিচ্ছি
34 Lord, I am appearing for the
Lord, I am for the state.
I have served upon all the respondents afresh, Lord. Lord, petitioner before your lordship is a doctor, MBBS degree, Lord.
Is a doctor?
Yes, Lord.
Yes.
Having MBBS degree and now serving
Yes.
in a hospital, Lord.
Then-
He appeared in postgraduate, Lord, eligibility and entrance test, Lord, that's NEET, national, and was qualified, Lord. And his documents are verified by the concerned authority in HON'BLE, and his date for counseling was fixed on 16th February to 19th February before the Diamond Harbour Postgraduate Medical College and Hospital. There he appeared and submitted his documents, and Lord, in the process of medical examination, my Lord, it took much time, my Lord. And on 19th, in the second half,
Tell me one thing. The admission fee was deposited, but the admission could not be finalized due to missing original degree certificates.
no, Lord, on that date, that is on 19th, last 19th February, on the last date, he would not bring the original certificate.
Could not bring.
Bring, Lord, that was not with,
These certificates are there with you.
yes, not on that date.
You have the
Yes,
certificates.
Lord, I have the certificate.
Why did you not produce at the time of
Lord,
admission?
I was under impression that as all documents have been verified by the Sasko, my lord. I did not bring the original, my lord. That is, and my lord, on the next date when I went there,
It was closed.
Admission portal was closed.
Yes, what is to be done?
My lord, they have given representation which is not readable.
No, my lord.
Which page?
Annexure P9.
Presentation, my lord, that was only written in the representation that due to
Take instruction as to what can be done with this candidate.
Okay, ma'am.
All right, please to come. The petitioner participated in NEET PG 2025. Stop. He was allotted a seat for NBEMS diploma. List of dates within bracket obstetrics and gynecology at Diamond Harbour Government Medical College. Stop. Prior thereto, all the documents of the petitioner were verified at Shasta Bhavan, and a verification certificate was also issued. Where is the verification certificate?
that is, my lord, that is, my lord, page 26. Answer P7, my lord, and page 27.
The document verification certificate is annexed at pages 26A and 27 of the writ petition. The petitioner was directed to report to the college on 17th of February 2026. The admission of the petitioner could not be completed on the said date. The petitioner paid the admission fee of rupees 1,25,000 on 19th February 2026. But as the original educational certificates were not readily available with the petitioner, his admission could not be finalized. The admission portal closed with effect from 20th February 2026. The petitioner approached the Directorate of Medical Education, Shasta Bhavan.
They informed that unless order is passed by
2026, praying for conclusion of his admission. There is no response till date. Paragraph. Learned advocate representing the state respondents is directed to obtain written instruction from the Director of Medical Education as to whether the admission process of the petitioner can be concluded in the present session. Which session? Which session is it?
That is the 2026, Lord.
Session बोलता है ना, लिखूं की बोलना? Can be concluded or not, as the petitioner has already deposited his admission fee and completed the document verification stage successfully. Released 21st of August, urgent motion.
I am for the petitioner. Last occasion, I have completed my submission.
Completed your submission?
Yes. I relied certain judgment, and now your lordship was about to pass an order.
Wait, then I have to refresh my memory. What is it?
Thereafter, your lordship was pleased to grant liberty to my landed friend to take
Fixation of
instruction and to
taking into past service temporary status. All right. Till and record pension has actually served on and from ought to be taken into consideration. Yes.
Lord, now, my lord, I've taken instructions
Yes.
to your chapter to the other one. Lord, here the stand remains the same, my lord, that this was a
It has been allowed from 80, you want from 76. 4 years.
yes.
All right. Yes. What is this reason order which is annexed? Is it in connection with this matter?
my lord, yes, my lord.
Naran Chandra Ghosh. What is?
Page 39 of my writ
My
petition.
lord, it is also there, my lord, in the writ petition, my lord.
All right. This is what is under challenge.
Yes.
This is what is under challenge, my lord.
So he sticks to the point that
Yes.
it has to be from 80,
1st of December 1980.
yes, 1st of December 1980, and past service cannot be considered.
It was a special case, my lord, given to my lord 76 to 80, my lord, what was considered. The effective date, my lord, remains 80. And my lord, that was only as a special case. In many cases, my lord, it was seen, my lord, that not all of them, my lord, had the necessary qualifications and also from 80, my lord, they went into a full-time position, my lord. Otherwise, these were all, my lord, temporary, irregular teaching positions, my lord.
This WPST 532, did you give?
Yes, my lord.
You gave.
Yes.
2014, volume 3, CHN 608.
608.
CHN 2014, volume 3, CHN 608. And there's also 2014, volume 2, CLT 444.
WP 81. 2014. Yes, 608.
Nimai
Nimai
Chandra
Chandra.
Chatterjee. Yes, ma'am.
Please come.
ঘটনা দিদিকে দিয়ে দাদা এটা হ্যাঁ
ওটাই ইকুইভ্যালেন্ট
ও আচ্ছা হ্যাঁ ওটা ক্যালকাটা ল টাইমস এর রিপোর্ট আছে
The recent order dated 13th January 2023 passed by the
Deputy Director of Public Instruction. Yes, Director of Public Instruction.
Public Instruction, rejecting the petitioner's prayer for taking into account his past service in a temporary post for the purpose of granting pensionary benefit is impugned in the instant writ petition. Stop. The facts of the case are that the petitioner joined as full-time temporary lecturer in a higher secondary unit of a college on 15th of July 1976. Stop. His service was approved by the competent authority with a proper scale of pay with effect from 15th of
That is page 19, my lord, but
এটা ছেঁড়া নেই
the date was not, probably the defect was not there. Page 20, my lord, 20. Sorry, page 19. 22nd of May, 1981, that's the mail.
পেটেন্ট লোক লাগবে স্নেহা মানে
1981.
6 January 1981, that circular, my lord, that gives effect from
His service was approved by the competent authority with effect from 5th July 1976 with a proper scale of pay. বললাম 15th of July 1976. Stop. Wide geo number 19 hyphen EDN within bracket CS dated 6th January 1981.
এটা দাও না
The state government introduced the graded scale of pay for teachers who could not be absorbed into regular lecturer posts with effect from 1st December 1980. Stop. The petitioner's service stood confirmed under the said scheme with effect from 1st December 1980. Stop. The petitioner retired on attaining his normal age of superannuation on 1st August 2009.
2014. আশা করি থাকবে এসএসসি অনলাইনে থাকবে
The petitioner has received his pensionary benefits upon taking into consideration his period of service from 6th January 1981. 1st December 1980. 1st December 1980. Stop. The petitioner submits that at the time of calculating his terminal dues, comma, the period of service rendered by him in his temporary post ought to have been taken into consideration by the authority. Stop. The authority has, not authority, the DPI. উপরে যেখানে বললাম না Director of Public Instruction আর ব্র্যাকেটে DPI করে দেবে. The DPI has rejected the prayer of the petitioner for providing him pensionary benefit for the period 15th July 1976 on the ground that the service rendered by the petitioner prior to his confirmation on 1st December 1980 was a temporary one. Stop. There wasn't any proper scale of pay according to which the benefit is to be calculated. Stop. Paragraph. Controverting the stand taken by DPI, comma, learned advocate for the petitioner relies on the judgment delivered by the Honorable Division Bench of this court in the matter of Nimai Chandra Chatterjee and others versus State of West Bengal and others, reported in 2014 3 CHN 608, wherein the court took into consideration the DCRB rules and held that the period of service rendered by a government servant on a temporary basis must be reckoned for the purpose of qualifying service and consequently payment of pension, comma, provided the service is followed immediately without a break by permanent service. Stop. It has been submitted that there has not been any break in service of the petitioner when his service stood confirmed on and from 1st December 1980. Stop. The service of the petitioner was continuous and the authority ought to take into consideration the previous service prior to confirmation for the purpose of grant of pensionary benefit to the petitioner. Stop.
Is this Nimai Chandra that was relied subsequently in another division bench, SLP preferred, SLP dismissed. That I also want to supply to Lordship.
Prior to that, say Ghulam Zikriya.
This Ghulam Zikriya is subsequent to Nimai.
Yes.
Yes.
Zikriya is
Now,
subsequent to
Ghulam,
Nimai.
in Ghulam Zikriya, my lord, Nimai has been, my lord, referred.
Considered.
Yes. Now, against this Ghulam, there was one SLP. SLP dismissed.
Yes.
I have handed over to Lordship.
Reliance paragraph there has also been placed on the judgment delivered by the Honorable Division Bench of this court on 16th February 2015 in WPST 81 of 2014. Sheikh Ghulam Zikriya spelling versus State of West Bengal and others, wherein also the court was of the opinion that the temporary service rendered by the employee cannot be altogether ignored, and the government should condone the deficiency in the qualifying service for the purpose of grant of regular pension. Stop. The order passed by the Honorable Division Bench in Sheikh Ghulam Zikriya was carried in appeal by the state, and Video order dated 17th of July 2017, this special leave petition stood dismissed by the Honorable Supreme Court. Stop. These are the judgments?
Yes.
Learned advocate representing state respondents submits that as the initial appointment of the petitioner in the year 1976 was a temporary one in a higher secondary unit of a college, which is separate from the main college, accordingly, the said period cannot be taken into consideration for the purpose of calculating pensionary benefit, calculating a grant of pensionary benefit. Stop. It has been submitted that the government order of 1981, relying on which the service of the petitioner stood confirmed, was a one-time benefit which was granted to the lecturers whose service who could not be absorbed in the regular post. Stop. For the purpose of granting this benefit, the government introduced the graded scale of pay, and the petitioner's service was confirmed under such scheme with effect from 1st December 1980. Stop. Paragraph. It has also been contended that the state has applied this consideration uniformly in respect of all the employees who got the benefits under this scheme with effect from 1st December 1980. Stop. There is no reason for adopting a different stand in respect of the petitioner. Stop. It has been argued that as the scheme pursuant to which the petitioner's service stood confirmed is with effect from December 1980, the service of the petitioner rendered prior thereto would not grant him any special advantage, or else the same would amount to discrimination in respect of the other similarly circumstanced employees. Stop. Prayer has been made to dismiss the writ petition. Now, prayer has been made to dismiss the writ petition by not interfering with the impugned order. Stop. I have heard the submissions made on behalf of both the parties and have perused the materials placed before this court. Stop. The fact that the petitioner rendered service as whole-time temporary lecturer in the higher secondary unit of a college since 15th July 1976 is not disputed. Stop. It is also not disputed that the service of the petitioner stood confirmed with effect from 1st December 1980, and the service of the petitioner was all along continuous without any break. Stop. The the issue as to whether past service of an employee is required to be considered for the purpose of calculating the pensionary benefits calculating and granting pensionary benefit has been conclusively decided by the court in the matter of Nimai Chandra Chatterjee within brackets Supra. Stop. The submission of the state that the employees were appointed temporarily on sanctioned posts on unsanctioned posts cannot be taken into consideration was duly addressed by the Honorable Division Bench. Stop. The court.
My lord is looking at Nimai Chandra Banerjee, my lord. My lord, Nimai Chandra Banerjee, my lord, would also be pleased to take, my lord, 17 and 18 of DCRB, my lord, is also set out.
Yeah.
So, my lord, whether, my lord, the conditions, my lord, of Rule 18 of DCRB, my lord, A and B, my lord, under B, my lord, 1 and 2, and my lord, C is there. My lord, C is the service must be paid by the government, and prior to that, my lord, substantive and permanent, or of permanent status, or quasi-permanent. My lord, then it was relaxed, and 22(1) said that if it is followed, my lord, by regular service. So, my lord, these conditions, my lord, this is not clear, my lord, as to whether from 76 to 80, my lord, these conditions in DCRB were satisfied, because the division bench placed it, my lord, reliance wholly on 17, 18, and 22(1) of DCRB, my lord. This, my lord, as for my submissions.
Yes, I understand. But the very fact that what was primarily considered that the service was temporary, unsanctioned post, without a break, continuity maintained.
Yes.
All this is fulfilled in this case.
And paid by the government, my lord, 76 to 80.
Was he not paid by the government?
It's the after, my lord, here.
The instruction that your law officer has sent,
My
it
lord.
mentions that his service was approved by the competent authority with effect from 15th of July 1976, and his pay was fixed in the pay scale. So there was a scale also fixed. Who paid you from 76 to 80?
Government?
Government paid?
Yes. There was not any
In the writ petition, my lord, I was trying to look at it, my lord, paragraph 2. When it was selected for appointment as a whole-time lecturer for commerce stream of HS unit at Chandidash Mahavidyalaya.
Government aided institution. It's a government aided institution.
Very well, my lord. If it's a government paid, my lord, I should not join issue. My lord, because, my lord, it was issued by the principal.
Sure, it was.
That's the reason I was asked to return the PF.
You were.
Yes, and I have since 1976. That document also I have annexed, my lord.
আচ্ছা কোথায় ছিলাম was also by the division bench. Stop. In the present case also, the petitioner was receiving pay from the government for the period during which he was in temporary service. Stop. At the time of confirmation of service in the regular post with effect from 1st December 1980, the petitioner was directed to refund the provident fund amount that he received during his temporary service period, which the petitioner did. Stop. The very purpose for directing the petitioner to refund the provident fund dues would imply that the state intended to maintain the continuity of service of the petitioner. Stop. The Learned Counsel, paragraph D, the Learned Counsel for the state respondents has tried to distinguish the facts of Nimai Chandra Chatterjee within bracket Supra with the facts of the present case. Stop. It has been submitted that Nimai Chandra Chatterjee within bracket Supra takes into consideration the DCRB rules, comma, which is not applicable in the present case. Stop. Paragraph. It appears, paragraph D, it appears that though the DCRB rules may not be applicable in the present case, but the ratio of the a decision in the matter of Nimai Chandra Chatterjee appears to be completely applicable in the facts of the present case. Stop. Paragraph. In Sheikh Ghulam Zikriya, comma, the Honorable Division Bench took into consideration the decision passed by the Honorable Supreme Court
State of
reported judgment.
No, Supreme Court, no.
A judgment reported.
All judgments are relating to DCRB, isn't it?
yes, no.
The other one also, the Pastu Dev Singh.
All are is DCRB, either DCRB 71 or DCRB 81. That's the difference.
Okay, ঠিক আছে. Paragraph. The Ghulam Zikriya division bench reiterated the principles laid down in the matter of Nimai Chandra Chatterjee within bracket Supra. Ghulam Zikriya to Supra. ঠিক আছে? The
Chatterjee হবে আমি ঠিক করে নিয়েছি
in the present case, comma, the petitioner has been paid his pensionary dues after taking into consideration 33 years and 17 days of his service. Stop. If the period from 1976 till 1980 is taken into consideration, comma, then he would receive a higher pensionary benefit. Stop. Paragraph.
It's called full pensionary benefit. No?
How much is the difference?
Huge difference.
It's a full pensionary benefit.
It's proportionate basis. No?
Full pensionary benefit. Stop. Next. As it appears that the petitioner has rendered continuous uninterrupted service from 15th July 1976 till his superannuation, and he had been paid his salary by the state on and from the first date of his appointment in July 1976. And he has also been paid Provident Fund dues on and from 1976, there is absolutely no reason as to why pensionary benefit cannot be extended, taking into consideration his first date of appointment on 15th of July 1976. Stop. The Director of Public Instruction is accordingly directed to calculate the pensionary benefit of the petitioner on and from his first date of appointment on 15th of July 1976. And issue fresh PPO, revised PPO at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. It is made clear that the petitioner would not be entitled to receive any salary for the that apart from calculating, it is made clear that apart from calculating his pensionary benefit, the petitioner would not be entitled to any other benefit. Do you claim anything?
No, I'm getting the past, I say area pension. On the basis of this revised.
No, that is all right. But apart from pension, because you have been paid your salary.
Yes.
And nothing more to be paid.
No. Only revision of pension and consequential benefit.
ঠিক আছে তাহলে এই লাইনটা কেটে দিন apart from টা কেটে দিন the additional financial benefit along with the arrears shall be paid to the petitioner, paid and disbursed in favor of the petitioner at the earliest. ঠিক আছে
61 তো আমরা নেই
The impugned order of the DPI stands set aside. Anything more?
Time period is to be
8 weeks time for the revised PPO and thereafter disbursal at the earliest.
Yes. And the area is to be paid, Malo, kindly.
Yes, area also to be paid. Anything more? Any of your submission which I have missed?
We are
more or less
covered, my lord, because this is
I'll check up at the time of revising.
Great, Malo.
My lord, in these situations, my lord, when instructions are issued by these authorities, they cannot go beyond, my lord, that if a decision is taken prior earlier, my lord. That is their difficulty, my lord. I guess.
Right, perfectly all right. What will the court do otherwise? Court has to do some work. আজকে আছেন?
That 38 আছে
36? Yes.
And for the state.
Yes.
Let's see.
Unmarried daughter family pension.
Yes, Lord.
What is your submission?
My lord, in this matter, the objection was raised by the DGGP and on
By
the DPPG
Yes.
on the 22nd of May 2026, and the same was communicated to the petitioner on 29th of May.
What is the objection?
In my lordship, legal year certificate that I have submitted before the authority, lordship. That is the documents are required to be submitted. 36 issued by DM, lordship.
Issued by DM?
Yes, lordship.
What does the DI say? The DPPG says?
Current legal yearship certificate.
Current
legal year certificate.
Which one you have given? How old is it?
In the 22 Lordship DM issue, therefore I have submitted in the 23.
It was made on 22nd of.
Case is furnished from computer showing
it is
that the
26.
not receiving ঠিক আছে, certificate of stoppage of fresh current legal aid certificate from the government. What does this fresh current? Every year it is not required to be taken, is it?
My lord, because there are about 12
Others.
legal heirs and all are approx 50 to 70. So, that the exact date of birth and the age will be determined. That is why the requirement is there.
Page 36 is not sufficient. Application was made in 22 with page 36.
Page 36.
Then why will a certificate of 26 be required? And you are the unmarried daughter?
Yes, Lord.
Unmarried daughter. No objection was given by the other legal heirs.
Page 36, you see, there is only, no, there are two unmarried daughters.
One has already been accepted.
Another unmarried daughter given no objection, Lordship. I have annexed in the petition
Yes.
and I have submitted the same.
And the widow daughter has also given no objection.
Yes, Lordship.
Won't page 36 suffice?
Yes.
Please come. The family pension of the
My lord,
being
two more
the-
documents are required. Two more documents: certificate from competent authority showing that the unmarried daughter is not in receipt of any pension.
Who is going to give this certificate? The pension sanctioning PSA is the pension sanctioning authority's request to furnish a certificate. So she is not required to furnish.
And the certificate of
I have submitted, Lordship, income
Issued by
certificate
the
issued by SDO.
Treasury
submitted income
officer is also required. See, it has to come from the treasury officer. So what the petitioner is to submit is the main thing. The others, the DPPG will obtain from the competent authority. কি বললাম? Unmarried daughter of a deceased assistant teacher.
Peon, Lordship. Peon, not teacher.
Oh, teacher নয়. Group D staff. Cannot be paid for want of certain objections raised by the DPPG staff. It appears that the petitioner is required to furnish a fresh current legal heir certificate from a competent authority, where from the date of birth of all legal heirs of the deceased. Here also it is mentioned teacher.
Yes, by mistake it is written teacher.
Deceased employee can be understood. Where is the date of birth? The legal heir certificate does not disclose the date of birth.
Yes, Lordship.
Then the date of birth will be required.
Yes, it is the defect of the DM, Lordship. I have, when I affirm the affidavit, all legal years.
You obtain fresh one. ঠিক আছে? On a perusal of the legal heir certificate annexed to the writ petition, it appears that the date of birth of the legal heirs are not mentioned therein. Stop. The paragraph B, apart from the legal heir certificate, further certificate from the competent authority showing that the eligible unmarried daughter is not in receipt of any pension from any government/undertaking is also required, and the certificate of stoppage of pension since the date of death of the family pensioner, that is the widow of the deceased employee, issued by the treasury officer, is also required to be submitted. Stop paragraph. the petitioner is directed. Did you receive this communication?
Yes, yes, your lordship.
The petitioner is already in receipt of the communication of the DPPG dated 22nd May 2026. Stop. The petitioner is directed to provide all the necessary documents to the District Inspector of Schools, SE Purva Mendipur, for the purpose of processing the pension file, the family pension file of the petitioner. Stop. Paragraph. The DI shall take steps in the matter immediately on receipt of all documents from the petitioner. Disposed.
So kindly directed to the DM to issue legal year certificate. As
You
early as
apply first.
I have applied again.
Where?
Her date did not
Then
apply in your lordship.
it cannot be done on air.